May I please accept division by accept. Let's see if I may be allowed to move in central excise appeal on Monday. Lord.
Hmm?
Listing of a central excise appeal on Monday. Lord. It was filed on 31st January. Lord.
Appeal. What appeal?
Central excise appeal.
Central Excise Appeal.
Lord.
That is taken up by which bench?
By bench, special bench.
Special bench.
Lord.
Have you, when did you file?
It was filed on 31st of January.
Okay, what is the urgency?
Let's see, because let's see, the petitioner has filed a contempt petition before the CCI Lord.
Uh-huh.
An appeal has already been filed, so we want to move.
Okay.
Much.
Right.
May it please your lordship, I beg to mention item number 10, lordship.
Item 10. Yes, what do you want?
Lordship, kindly, after 2 weeks, lordship, my senior has some difficulty today.
Okay. Who's your senior?
D. Talukdar.
Okay, you have circulated the adjournment slip, isn't it?
Yes, lordship.
Other side have no objection?
Lordship, other two matters, analogous matter, I have informed other council, lordship. 10
Okay,
and 11, lordship.
Okay.
11 and 12.
they're all together.
Yes, lordship.
Mr. D. Talukdar, learned counsel for the appellant in criminal appeal number 301 of 2022. He said to have some personal difficulty to conduct the case today. After circulating the adjournment slip and taking the consent of the party, a mention has been made on his behalf by Miss
Ms. B. Goswami.
B. Goswami. Next para in view of above, let the matter be listed. We fix a date or month?
March.
Case be listed in the month of March on a date to be fixed by the registry.
Okay.
What month of March for hearing, huh? On a date to be fixed by the registry.
Okay.
Yes,
May I please, Julius? I beg to mention, I think about 8 and 9, my lord. We have
okay.
some
For the
adjournment
appellant,
slip also, my lord.
okay.
Can it be on 17th, my lord, next week? We have some urgency, my lord. There's
What is the urgency?
high pending.
Hmm? Then you should not have taken adjournment today.
Sorry, my lord, today we are not ready, my lord, that's all.
17, I don't know. It's just next week. There are many matters lined up, you see.
Kindly, my lord, can it be on 17th, my lord?
You have in the month of March.
Tuesday, my lord, some urgency is there, my lord.
Hmm? Difficulties there.
17th.
You take a date in March, I'll give you a date. 16th? 16th.
The method. Also for the day then, my lord.
Huh?
Please mention before the bench, my lord.
All right, as prayed for by the learned counsel for the appellant.
I'm sorry, ma'am. Some urgency is there.
The matter stands adjourned for the day. Okay, you take it up.
Obvious.
I please your lordship. Lordship, I beg to mention listing of a criminal appeal for Monday.
New case.
No, lordship.
Then take it up before the registry. So that also. Approach the registry, please. Yes. Call.
For admission, item 1.
May I please, your lordship? This is a 2-year conviction, your lordship. 2 years. 2 years, your lordship. What has happened, your lordship? The case, your lordship. In this case, citizen charges were framed under section 302. And then, your lordship, some of the accused has been convicted for life, your lordship.
Have they filed an appeal?
Lordship,
Have they filed appeal?
they have also preferred an appeal, your
Appeal.
lordship. That has not been listed.
Okay, we'll admit the appeal then.
This appeal can be admitted.
Yes.
Can be admitted, madam.
Part Mr. S. Bothakur, learned counsel for the appellant who submits that by filing this appeal, the appellant has challenged the judgment in order dated 12/12/2025
Lordship.
passed by the additional sessions judge FTC Sibsagar in session stage number 41 bracket S-S close bracket of 2020, whereby the appellant has been convicted to undergo rigorous imprisonment for 2 years, then to pay fine of rupees 3,000 with a default clause on being convicted under section 354 bracket capital A close bracket 1 bracket small Roman 1 IPC. of the learned counsel submits that the other co-accused persons have been convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life with fine. Next paragraph. In view of above, let the appeal be admitted for the TCR. Issue notice to the state. Mr. R. Kaushik, learned additional PP, accept notice. Extra copy?
My lord.
The extra copy of the appeal be furnished to you within 2 days.
That notification is because of that it has to be taken up before division bench.
Lordship, lordship.
We have seen it.
I is there,
I is there.
your suspension of, sir.
Where's the IA? Okay. This is the matter again on receipt of TCR. Heard Mr. S. Botakur, learned counsel for the applicant, who submits that by filing this application, the applicant seeks suspension of the sentence passed by the learned additional session judge, FTC Sagar, in sessions case number so and so, okay? Convicting the appellant under so and so. Same thing, then next para, issue notice, returnable by 2 weeks. Mr. R. Kaushik, learned additional PP, accept notice on behalf of the state.
Will file objection.
List again on so and so.
Lordship, till then, your lordship, he may be allowed to, because 2 years conviction only. Not
No,
five.
but what was the, after your conviction, what happened?
Your lordship, I was granted bail, your lordship.
When? Why, which order?
That order we have not annexed, but.
No, you should have annexed it.
It is here, your lordship. What is it?
Page?
Page 58.
He's on bail at the moment.
Lord, he is on bail.
Page 58. Page 58.
Page 58.
58. Something wrong with your pagination. From 50, it suddenly jumped to 60.
He is on bail, your lordship. Since 2 years, your lordship was granted bail.
By the convicting court.
Have you seen it?
In
Have you seen it somewhere?
It is there, your lordship. In the main petition, your lordship may kindly see page 90.
One night.
Page 19.
Anusanga.
No, after 12/1/2026.
Since, your lordship, we have filed the appeal, your lordship. We have approached the learned trial court, your lordship, and submitted, and thereafter this order is extended.
Extended till 12/1 only.
No, after that, on 12th, your lordship, we filed a petition, your lordship, saying that we have already moved this honorable court.
Where is the order? Any order passed?
Or they have allowed me to continue, your lordship.
By
That
which order?
Right now, I don't have, your
You should have had that order.
lordship. But your
You want
lordship,
to remain on bail.
that's the, I am on,
If you're allowed to remain on bail, then what second order do you require from this court?
no, your lordship, till your lordship, since this case is pending before this honorable court, that is why your lordship, this
Fresh order.
ultimately, what
See, Mr. Botakur,
lordship,
you were on bail before the conviction.
lordship,
When the order was passed on December 12th,
lordship,
convicting you, you were allowed to stay on bail.
lordship.
Fixing 12/1/2026.
12, your lordship, this case is filed before 12, your lordship, and since it was not listed, therefore, your lordship, we approached the learned trial court, your lordship, and saying that we have already prepared a application, your lordship, then thereafter it is.
So I'm repeating again, where is the order of the trial
That
court?
order right now I don't have, but your lordship, that's on instruction I am submitting, and that's the fact. Otherwise, he would have been in jail, your lordship. And I would have make a separate application for him in that case.
No, there should be a statement also in your application.
So since that has, your lordship, after filing of this petition on 12th, your lordship, since it is not listed, because your lordship, what has happened, I am submitting, your lordship. Since this is an order passed, your lordship, but it was initially decided to be listed before the honorable single judge, your lordship. Then registry took up the matter, and then notification came on the issue. And when that notification.
Okay, okay. Any order was passed by the trial court? On
Yes,
12th,
for allowing me to continue in your
you
lordship.
produce that during the course of the day?
Certified copy, probably it will not be possible to get today, Your Lordship. But it is, my instruction is that your lordship it was.
Not certified, even if you have a true copy, produce that. We want to see.
Then your lordship may take it up on Monday, your lordship. Otherwise, it will not be possible. Today, your lordship, I can't take.
Monday. The learned counsel for the applicant submits that the learned trial court, despite convicting the applicant, had allowed him to go on bail in view of the fact that the applicant was intending to prefer an appeal. And he submits that the said bail continues till date. Learned counsel to produce the copy of the order dated 12/1/2026, passed by the court concerned.
Normally, your lordship, less than 3 years, your lordship allows your lordship to go on bail, your lordship.
List again on Monday. Give a date.
It is lodged. The statutory appeal has been preferred against the judgment of conviction matter recorded on 01/12/2025 by the learned session judge Sribhumi matter. Convicting the appealants to undergo for a period of sentencing them to undergo mandate RI for a period of 12 years along with fine lodging. Page 1 is the one.
Conviction is under
It's under
20.
20B mallet of narcotics. 20B to C.
Nice. Within time, isn't it? Appeal is within time.
Yes, madam.
Part Mr.
M.A. Chaudhary.
M.A. Chaudhary, learned counsel for the appellant, who submits that being aggrieved with the judgment dated 1/12/2025, passed by the Court of Special Judge Sri Bhumi in special bracket N, case number 160 of 2022, convicting the appellant under section 20, small within bracket small b, and within bracket small Roman 2, bracket small c of the Indian PS Act and sentencing him to rigorous imprisonment for 12 years with fine of rupees 1.5 lakhs with a default clause, as preferred the instant appeal. Next panel, let the appeal be admitted. Call for the TCR. Issue notice to the state. Mr. R. Kaushik, learned additional PP, accept notice on behalf of the state. Extra copy of the appeal be furnished to you. Who is number 2?
Malad, yes, if the informal police officer, so my learned friend CJ can represent him.
Since the respondent number 2 is the police or excise
Officer in charge, malad.
of,
Officer, he was the officer in charge of Churaibai watch post matter.
sorry,
He was the office in charge of
Of what?
watch post.
where is that?
Yes, page 20, the check can have it, malad, and 10, malad. Page 20.
20.
Yes, ma'am. He was examined as PW5, the informed.
Since the respondent number 2 is the officer in charge of Churai Bari, who has been examined as PW5. But you have included him by name.
You have to have written the informant ballot as officer in charge or to have been there, my lord.
What do you say, Mr. Kaushik?
Mistaken,
But usually by name, we don't represent.
typographical error, my lord. That's it.
Big error.
Yes. Not to have been, my lord, the officer in
At
charge.
this stage, will not say anything. If you want, you amend it. Or you'll take steps.
With sub the copy to my lord, APP, my lord.
You have implemented somebody by name.
Then,
You have not even mentioned that is an inspector or OCS.
yes, my lord.
Nothing like
Then we
that.
would like to amend, my lord, amend the cost title. my
Then you amend, for that you don't need liberty. List the matter again on receipt of the LCR. TCR.
IA is there, my lord, that may be considered after this.
Heard Mr. So-and-so, learned counsel for the applicant who submits that by filing this application, the applicant seeks suspension of the sentence of the judgment in order so-and-so, details already given. Issue notice, plannable by 2 weeks. Mr. R. Kaushik, learned additional PP accepts notice. Extra copy of the application be furnished to him. Applicant, the respondent would be at liberty to file objection to the IA. If so advice, list the matter again on so-and-so. No, you can give a date. Or you want it to be considered after LCR, isn't it?
Yes, my lord.
List again on after receipt of the TCR.
For orders, item 3.
And by order that 3725, my lord, registry was directed to serve a copy of the apartment to the my lord, amicus curiae Ornav Das, my lord. Accordingly, it has been served, his name is also shown.
Correspond number 2.
You have a copy?
Yes,
No?
I wish to paper book.
Okay.
So it may be listed for hearing in the month of April, my lord. Everything is complete now.
It is submitted as a bar that a copy of the paper book has been served to the respondent number 2 in terms of the last court's order. Mr. A. Das, learned counsel appears
Correspond number. Then am I correct?
for respondent 2 as amicus and confirms that he has received the paper book. Next para, in view of above, registry to list the matter for hearing as per its own turn.
4 and 5.
It's an appeal against acquittal, lordship. And paper book is ready, lordship. I could not collect it, lordship. It come up. Otherwise, case may be fixed for hearing. I will collect the paper book.
What is the system? You go and collect or they supply you?
No, they informed us
Ah.
day before yesterday. I could not collect, lordship.
They inform you that come and collect.
Yes.
Like that. Oh,
Yes.
I see.
Otherwise,
Yeah.
lordship, if lordship permits, we can collect it from the court also.
Extra copies here?
That could be here.
Item number 4, I have not collected. In item number 5.
No, you go and collect there only. In case there is some discrepancy and all that difficult.
Lordship.
You are Mr. Ganguly, is it?
Yes, yes,
S. Ganguly.
yes.
A. Ganguly. Mr. A. Ganguly, learned counsel for the appellant, submits that he has been intimated to collect the paper book and which he will be doing within the course of the day. Stop. He submits that the matter is otherwise ready for hearing.
So in item number 5, the IA is there for disposal, your lordship. So if the matter can be.
5.
Item 5.
Arising out of the same judgment, lordship, I have filed an appeal against acquittal, and these 2 persons who were convicted, they have filed appeal in item number 5. Arising out of the same judgment.
On another date, your lordship, for orders.
You have filed an appeal against acquittal.
Yes.
I have filed.
And you have-
Against conviction.
Arising out of the same judgment, there were 6 accused persons
What-
who were tried. 4 of them were acquitted.
Ah.
I have filed an appeal against the acquitted person, and she has filed appeal for the convicted. person.
Convicted person.
Yes.
And IA is for the suspension of success.
Person.
Any objection filed?
But I don't have copy. I think I have not
It's
filed.
filed.
I-
Mentioned in the order.
Otherwise, my lord, paper book is ready, everything is ready. Later can be fixed for hearing.
First, let the IA come, your lordship. For the suspension of sentence.
Okay, we'll list it. They are clubbed together. The problem is that they're clubbed together.
Come up for orders, your lordship.
Next para, the learned counsel for the applicant in IA criminal number 381 of 2024. Miss, your good name?
F Hussain, Your Lordship.
F. Hussain submits that the IA is filed by the co-accused person who has been convicted. And the instant application is for grant of, for suspension of the sentence. To stop, she therefore submits that the IA may be taken up for consideration even before the hearing is conducted. Can we give a date considering the same? Let this matter be, let the IA be listed on 23rd.
Convictions for life.
That's
23rd February.
deeply obliged, Your Lordship.
Item 6.
Right, Lisa Lordship, in this matter, my lord, we could not take fresh step, my lord, because my lord, we could not collect the present address of the
POCSO,
opposite parties, my lord.
this is POCSO.
No, my lord.
Steps on whom?
Appeal against acquittal, my lord.
Appeal against acquittal.
Yes, my lord.
So what is to be done?
Police station, my lord, Sanmari police station.
Chanmari Gauhati.
Yes, my lord, go ahead.
On which respondent?
2, 3, and 4, my lord.
They are the accused persons.
Yes, my lord, they are the accused persons.
Please write, this is an appeal against acquittal. Learned counsel for the appellant submits that you could not serve notice to the respondent numbers 2, 3, and 4.
Actually, we have take a step part, my lord, in the earlier occasion, it was.
2 is also there or only 3 and 4?
What added for 3 and 4 and answer received in respect of number 2 money.
Who has received notice? State number 1. Number 2, who is number 2?
Number 2 is the private person, accused person. my lord.
Has he received?
Acquitted person.
Has he
Not-
received notice?
Not yet,
3 also has not received.
not received,
4 has also not received.
not received, yes.
So you want to take it by way of through the police station.
Yes, my lord, 2, 3, and 4.
Please continue despite having taken steps through registered post. To stop, the learned counsel submits that he may be allowed to take fresh steps through the police station concerned. Now, what is the procedure through the police station?
Really, if we take on, we directly send it to the police station, then
Ah.
police goes to the house of the concerned person, the address.
No, now he says he wants to take through the police station.
Then
Submit the registry, no,
to registry, not to our-
arrest. Arrest, my lord.
Sorry?
In POCSO
For-
cases, as per notification, it has to be through us. They will send.
No, that I understand. I'm talking about this case.
They
He
are
says he wants to take through the police station. What is the process?
through registry.
Thorough registry.
Huh?
Thorough registry, my lord.
You'll submit the steps and
Yes.
the registry will send it to the police station,
Police station.
not the not the appellant.
No, my lord, not by the,
Okay.
registry will take it. Serve the copy through the police station.
Brother, are you aware about this?
It can be served, it can be submitted before your office also, right? Public
Can be,
prosecutor,
otherwise it can.
then you can send it to the police station. I think that should be fine.
Generally,
Appeal against acquitted, they
Yeah.
avoid service. Lordship, most of the cases we have found, my lord. Yes, your lordship.
Now, what I'm seeing clarification is that he wants to serve through police station. Now, what is the procedure through police station?
Through police, they are to serve scan copy in cases of POCSO as you say, it's conviction.
No, what I'm saying is that whether appellant will individually go there and personally go, then through-
Council, they are to serve scan copy to us, then we'll do the needful through our PP's office. Yes.
AP's office. So that is it.
Some acquitted lordship generally raising post and all.
It didn't work, no? They're not accepting. Person is acquitted, why will he take the trouble of receiving notice?
Submit before office of PP.
My lord.
Next, madam, considering the prayer made, the learned counsel for the appellant shall furnish requisite copies of the memo of appeal to the office of the public prosecutor. And registry shall also furnish the requisite format to the office of the public prosecutor, and the latter shall cause service of notice upon the respondent numbers 2, 3, and 4 through the officer in charge of the police station concerned. Stop. The OC shall thereafter submit a report about service of notice to the same office. List again after 3 weeks.
Obliged.
37.
May it please your lordship. In this case, I am convicted and sentenced under section 6 of POSCO as well as post 370 of IPC.
Lordship, there's an issue as regards service because the IO is in a law and order situation because PM is coming to, he's informed to my junior, my lord.
No, advocate has entered appearance
Oh,
for respondent by filing a vakalatnama.
yes, done.
Your good name? AK? Mr. AK Hajong, learned counsel, submits that he has instructions to appear on behalf of respondent number 2, and he has filed his power. Stop. He, however, submits that he has not received a copy of the memo of appeal. Stop. Considering the same, the notice upon respondent number 2 is accepted to be complete. Counsel for the appellant to furnish a copy of the memo of appeal to Mr. Hajong
Within 2 days.
within 2 days.
Objection, we filed it yesterday. I don't know whether it's on record.
TCR has come?
Served on the-
TCR has come? IS also there?
as against IA, we have filed an objection just yesterday, my lord, in the evening.
Office to send a reminder to the trial court concerned for sending the TCR. Then in the IA, you write,
May come up in the coming week?
you have received a copy, Mr. Hajong?
No, we have not served. We have served on him, on the appellant.
That is the objection.
Yes.
I'm asking you about the IA. Have you received a copy of the IA? He's also a party here.
Yes, sir.
Mr. So-and-so Hajong, his learned counsel submits that he has instructions to appear on behalf of the respondent number 2. So accordingly, notice upon the respondent number 2 is accepted to be complete. A copy of the IA be furnished to him within 2 days. Ms. B. Bhuyan, learned additional PP, submits that objection has been filed. When did you file?
Last evening, I'm told.
Has been filed
Copy served on the other side, appellant.
yesterday. However, the same is not seen, is not available in the record. Office to verify and connect the same to the record. Respondent number 2 is also given liberty to file objection if so advised. List the matter again. When?
Next week, your lordship, on a hearing day, if your lordship may kindly allow.
He wants to file objection, so then it'll take some time, isn't it? How much time should you take? 2 weeks.
May I pray for a fixed date if your lordship may
Ah.
kindly. In the month of March, your lordship.
Oh.
On a Saturday, if your lordship may kindly.
Only working Saturday in March is 7th. Fortunately, 21st is a holiday, I think. Okay, list on 7th of March.
Deeply.
13, 14 of the supplementary list.
Is the lordship, my lord, 13, I think Mr. HRS Chaudhary, senior advocate, will do the case, my lord. He is coming, my lord, not yet reached.
13, 14, just a minute. What is it? 13, 14?
Lordship, 13, they have one IA, copy is not served on us.
13.
When we file copy has been served by the.
Lordship, let a copy be served on us, we'll file our affidavit, objection.
Last time you paid for 4 weeks' time
Yes, but they
Without-
did not
with-
serve copy on
without,
us.
without receiving copy.
Lordship, at the time of filing, we have already furnished the copy,
Oh,
your
but
lordship.
our office misplays, I admit it,
Give one more copy.
yes.
Ms. B. Bhuyan, learned additional PP, submits that the earlier, a copy of the application furnished earlier has been misplaced. And that
And I'm not sure about it.
she
Generally
requires,
happens, they don't.
she requires another copy. Counsel for the applicant to serve an extra copy
Xerox.
within 2 days.
Very long time this IA is pending, your lordship.
Once maybe it was rejected.
Yeah, earlier rejected.
When do you want it? Objection will be filed by which time?
Voluminous. Voluminous. 10 days at least,
Voluminous, but your objection will be 3-page only.
depending upon this one. Evidence.
2 weeks, at least 2 weeks. Okay.
Provided they serve a copy
Okay,
on us.
your lordship. Today I said, it said like starting 18 witnesses. Actually, 313, so there are many accused persons.
Yes.
There were the 313 is.
I know.
Small. That's why.
You're keeping a track of the dates. Give a date after 2 weeks. List on 12 March.
Published.
Part hard, I said 15.
Which is that Mr. Chetri,
Yes.
at the outset, we would like to put one thing across to you. See, today somehow we have our own respective single benches also. Quite a number of cases have been piled up. And since we've somehow just started yesterday, can we have this matter some other day? Because there's no point keeping in part heart also. This bench constitution may not continue.
Probably within a short time, I will finish it. Within a short.
No, others will have to, they have to reply also. And
Maximum half an hour, I will finish it. Maximum.
See, Arata Partner was said it's a single bench.
I've seen my letter.
there's another part heart also, which in fact we had heard at
In the part heart,
the other part heart we have heard with a,
Yes,
or
the
to a
second
great
part-
extent.
probably in second part of lordship heard at length.
Yes.
And only the one.
These two you had just opened yesterday.
Yes.
So let us have it some other day. All right.
Uh,
There's difficulty. Otherwise, we would have taken up. Because the bench may not be there again also after that.
Malata, since in my case, Malata, it will not take much time, Malata. Only
This
I
is
will
the-
supply the judgment.
See,
Three.
you are only concerned about your part. You have to be concerned. We are concerned with everyone's part. Your part, her part, our part, to write, bench. These are things.
Part of the result. Yeah, people who say.
Isn't it, brother?
Lordship.
See, criminal matters, appeals are not just like bail or something like that we can just briefly hear and dispose it of. Somebody is in jail or somebody is acquitted, so we have to meticulously give our consideration. That is why. Mr. Chetri,
Otherwise, Malata, I will not take much time. That's my submission before this honorable. I will not take much time.
Some other day.
yes, I think that'll be better, Mr. Chetri. Today is what? 13.
Please 13.
It will remain as part of my.
It cannot remain as part heart.
Oh, not okay.
No, she was keep it before your lordship.
Before lordship, my lord, let it, if your lordship desires to fix some other day, lordship will be, fix the matter and lordship will remain there as part of my lord. Any day, my lordship will take up the matter. Since
Nowadays
lordship
it-
heard the matter.
You know,
And-
nowadays it can't, I suppose, for a longer period, it cannot be. kept as-
This is a temporary bench, you see. The regular bench is
My lord, that
He's
is the
there.
matter, already I have initiated the matter, my lord, and the lordship heard the matter at length, my lord. And my
no, we have not heard the matter at length. You had just started You had just started and you were saying that your argument is mainly on dying declaration. You read few of the positions. That's all.
PW has already been read it out, my lord. Only 2 or 3 PWs are there. And they are very, they are not relevant otherwise. Only one PW.
Mr. Chetri, it's not possible. This is not the only case we are having today. I'm telling you, to be very frank. Bench 4 matters are piled up. I'm having single bench. Brother has a single bench, civil and bail. So we are hard pressed. Actually, that's why.
We are,
This
may I pray, my lord? Let the matter be remain as part at any other day, lordship, whenever it is.
No, we're not keeping it part. Not possible. Paucity of time would not permit us to hear the matter today, and accordingly, the matter is released from part hut. As paid for, let the matter be listed on so and so 19/2/2026 for hearing. All right, Mr. Chetri. Sorry.
16, part hard.
I'm otherwise very faint. I was supposed to do it all.
Right, please, also.
Yes.
Well, on dying declaration, my lord, I will just submit one judgment, my lord. Because my lord, dying declaration has to be at the first opportunity, my lord. When the person.
You had completed your submission, isn't it?
Yes.
Only that judgment you have to serve.
I have brought a recent judgment on dying declaration. I will submit that, my lord. And one more thing, my lord, if your lordship permit. Here, my lord, the treating doctor was not examined. When he was, after the injury incident, when he was brought to the hospital, that this has to be, my lord, crucial, my lord, to prove the nature of injury suffered at the time of admission in hospital. So this causes significant doubt, my lord.
Give your judgment. We'll hear the respondent number 2. Who is the respondent number 2?
Not present.
Mr. Sen. Where is he?
Not necessary. Formal party only. PP is there, man.
No, how can you say that? How can you say that for just a format, not necessary? Let him make his own submission.
My lord, but he is not present.
Which paragraph?
Paragraph, my lord, your lordship will come to para 60, 61, up to 69, my lord. Paragraph 60, my lord. I'll read from paragraph 61, my lord. This is regarding the dying declaration, my lord. 61, if your lordship permit, my lord, I'll cover up, my lord. And it was a full bench decision, my lord, where, my lord, the juristic principle has been laid down in paragraph 62, my lord. Full bench decision, my lord. That the dying declaration should be wholly reliable and inspire confidence. That is the thing, my lord. So paragraph 62, your lordship.
So these are the basic principles.
Yes.
I think it has been reiterated. That's it.
Paragraph 62, I'll reiterate, my lord. In this page 32 of my judgment, my lord. Whether the person making the statement was in expectation of death. It was not in expectation of death. Next is whether the dying.
That is not required under our law. In the statute only it is provided.
Yes.
That is, that irrespective of, even if he's not in expectation of death,
Yes.
the dying declaration can come. That's the law in our country. As far as I know, in some countries, only you are in expectation of death means.
Yes, yes.
But here it's not.
This only I am reading the principle, my lord. This. Number 2, 3, up to 11, my lord. These are, my lord, things to be seen, my lord. There should not be any reasonable suspicion to believe that dying declaration was put in the mouth of dying person. Because the person died after 2.5 months, my lord. That is the thing, my lord. So, person died on after 2.5 months. on 16 June, my lord, 2015. And possibly, my lord, this was not exhibited because that dying declaration is full of suspicion whether it was recorded actually on that date or not. That is the thing, my lord. And if it is not actually recorded, prosecution failed to prove the case, my lord. That is the crux of the matter, my lord. Because he was unconscious, my lord. IO says, PWA, that he was unconscious, and so in the hospital, nothing could be done, my lord. So that one aspect is that if he was unconscious, if was suffered such a grievous injury, and he will not lay in the home, my lord. The person who has suffered such severe injury, he cannot be put into the home for 3-4 days, my lord. Kindly say, my lord, that is a lordship will appreciate. That caused a very high suspicion from the beginning that the PWT informant has developed and exaggerated the facts by putting this into the mouth as doya. Person receiving severe injury, I also told I could not record as he was unconscious, not in a stable position. Then suddenly, my lord, after so many days, my lord, your lordship will see, after 4 years, PW1 coming to the dock for the first time.
You have to ask him.
Saying, was it?
Mr. Sen is not appearing. We'll go through your judgment. Okay,
Yes, my lord.
and consider it.
Or if the
Mr.
set in place now or after hearing the,
He's not here. What is to be done? We cannot wait forever.
Yes, fix for his.
Only his part, my lord, your lordship.
Ah.
after
for his
time.
part of
Correct. You submit what judgment you want to submit.
the first yesterday, my lord, because since my learned friend is harping the point, which is not in this statement, because their dying declaration,
Hmm.
the 161 statement, already I made it clear yesterday, that is only 161 statement because that has not been executed. So no point of arguing on that point, because that has not been executed. And regarding yesterday, learned friend said that my lord in 313,
Hmm.
the gossip remembers my lord, he was again examined. And I said that my lord, he will have to show how it prejudiced him.
Hmm.
Regarding that aspect, my lord, I'm being considered. Where I live in. Shall I read the relevant portion or
Yes, you made it if you want to.
last page, my lord?
Hmm.
Starts from the onus, third line.
Yes. Just a minute. You got it, brother?
The
That piece.
Para 11.
Next page. Next page.
last page,
The honest middle somewhere.
third line from top.
Third line. Yes, read.
The onus is upon the accused person to prove that by reason of his not having been examined as required by section 313 of the criminal CRPC, he has been prejudiced. No such prejudice has been caused to the accused person in this case. They never raised any objection at the time when the case identification period. These are basically the principle that he will have to show that what caused his prejudice. Here also they never raised anything. And I already stated, my lord, he has a right to be silent. This is regarding that aspect, my lord.
Hmm.
And dying declaration, my lord, because here there is no question of written dying declaration. It was as per the statement of the IO, but unfortunately that has not been executed. So the whole case remains on oral dying declaration of PW 1 and 3 made before PW 1 and 3, and to some extent the IO, because we can exclude the 161 statement, but we can certainly take the statement of the IO in respect of the statement made before him as an oral dying declaration. So in that respect, my lord, this is general principle, my lord. If it is confidence, my lord, there is no corroboration needed. If voluntarily made, my lord. There are 10, my lord. Then I read or my lord? Page 2 to 3, my lord, the relevant portion.
Read.
It starts from middle portion, my lord. The declaration must be, the rule of prohibition requires that, the dying declaration be subjected to scrutiny since the evidence is untested by cross-examination. The declaration must be accepted unless such declaration can be shown not to have been made in expectation of death or to be otherwise unreliable. Any evidence adduced for this purpose can only detract from its value but does not affect its admissibility. The dying declaration therefore may be tested as any other piece of evidence. Once the court reaches the conclusion that the dying declaration is true, no question of corroboration arises. The dying declaration cannot be placed in the same category as evidence of an accomplice or confession. So here, if there is no other doubt, then there is no corroboration is needed. And here from the deposition of PW 1, 3, 8, and PW 7, the doctor along with the medical evidence that clearly establishes that the person who made it, my lord, he was consistent and there was no motive for him to implicate a person. There's no reason, there's no reason to implicate a person falsely, man. And the general principle of lordship knows that while a dying person doesn't lie. That is the general principle. So this is another aspect, my lord. And regarding my lord, lapse of time from the date of injury and his death, my lord, which my learned friend has raised, my lord. I'm placing this as well. There are 16. 16. This case actually also deals with section 161 as a dying declaration, but I am not taking that point because that has not been executed. There are 16. Shall I read?
Yes.
Additionally, in our considered view, the High Court are in holding that this statement cannot be treated as dying declaration merely because the death of the deceased occurred after substantial lapse of time from their recording. Such an approach is clearly untenable since the law does not require that the declarant at the time of making a statement to be under shadow of his death or the expectation that death is imminent. Here, the time gap between the incident and the death is less than 2 months. In any event, section 32 of the evidence that contains no such limitation. What is pertinent is that statement relate either to the cause of his death or circumstances leading to it. So that lapse is not material. Only have to show that minus circumstances and what was the death, my lord. Here, if you also remember the statement that he stated that, my lord, they picked him up and thrown in the ditch, my lord. That correlated with the medical evidence, my lord. And circumstance, my lord, to that aspect, my lord, Proceed may peruse the evidence of PW 7, the doctor, who said that, my lord, death was by the injury sustained.
This postmortem doctor.
Yes, my lord, that obviously that opinion will postmortem doctor will only give.
Autopsy.
Autopsy. My lord, and yesterday my learned friend tried to project that, my lord, since he died after lapse of time, so this is not murder. It will be a culpable homicide. In that respect, my lord, I am listening.
In this case, the main issue is the identity.
Identity, yesterday I pointed out. Because the identity, my lord, in my humble submission, will not get a citation in that aspect because, my lord, this is a peculiar situation. There are 31, madam. Shall I read?
31. Yes.
There can be no stereotypical assumption or formula that where death occurs after a lapse of some time. The injuries which might have caused the death, the offense is one of culpable homicide. Every case has its unique fact situation. However, what is important is the nature of injury and whether it is sufficient in the ordinary course of the course to lead death. The adequacy or otherwise of medical attention is not relevant factor in this case, because the doctor who conducted the postmortem clearly deposed that death was caused due to cardiorespiratory failures as a result of injuries inflicted upon the deceased. Thus, injuries and the death were closely and directly linked. Same in our case. Last one, my lord. There are 9, my lord. Just one line I would like to point it out, my lord. The middle portion.
Yeah.
There are 9 last page. Middle portion I'm reading, my lord. Secondly, there is also nothing on record to show as to why the dying man would have falsely implicated the appellant. Natural presumption is that a dying man does not lie. If there be no motive for the same, if false implication would have been the motivation, so and so would have involved accused so and so with whom he had some dispute, but he has not named as so and so. So here also, there is no reason that he will lie. Regarding identity matter, I will not repeat my same thing yesterday I did.
What was your submission regarding identity? Yes, sir.
My submission is that my the PW 1 and 3
Hmm.
and the accused person, they and the victim, madam, they knew the accused person because he immediately named my lord Daya. And PW, my lord, this PW 1 and 3, they identified him dog. They said that I know the accused person. And PW 1 and 2, they say that the person who is standing in the door is my lord, his name Dansiang Pudai.
Right.
Danisang Pudai. And Danisang Pudai, vis-a-vis the person who is the accused, he in his 161, 313, he said, I'm so and so, and I'm also known as Daya. And in the Dictosera market, the incident happened in the Dictosera market.
Incident took place in Dictosera.
Yes.
Incident and the roadside, man, not named Dictosera, Kalibari area.
In any case,
Kalibari
PW said that this person is the same, but the person we know is Pudai. The Pudai said, I am Daya. That's his person. Because obviously the person died. So that identification that could not have been done.
May I reiterate, my lord, on 2 point, my lord. First, my lord, the 313 inculpatory part, my lord, cannot be made the sole basis of conviction. Yes, 313, they say, my lord, page 39.
But it can be taken into account.
Taken into
Taken into account, my lord. Page 39, 313, this was done after 5 months. They have recorded, they have obtained an answer. Is your nickname as Daya in your village? So that is not referring to any incriminating circumstances. Because that was stated by PW1, but that was never recorded, or that question was never put from what has been stated by from the mouth of PW1 and 3. That PW1 has stated that you are Daya, I could record. Nothing has been put. So, my lord, I am referred earlier to that judgment, Rajkumar Singh, my lord. Only that 2013 5 SCC. That is relevant para 32. Court has stated, my lord, that in
2013, 5 SCC.
2013 5 SCC, page 722. I already supplied, my lord, Rajkumar Singh, paragraph 31, 32, 36 and 41, my lord. Yesterday I did not read that judgment, my lord. I'll refer to that, my lord. This clearly says, my lord, that 31, if a lordship permit, small paragraph I'll read, my lord. 31 and 32. This must be clear, my lord, because such kind of weakness, they could not, prosecution could not fill up, my lord. Paragraph 31, in state of Maharashtra versus Sukhdev, this court observed that if there is no evidence or circumstances, may I read, my lord?
Read, you already,
Yes.
you already started reading.
If
Complete.
there is no evidence or circumstances appearing in the prosecution evidence implicating the accused with the commission of the crime with which he is charged, there is nothing for the accused to explain. I need not explain. And hence his examination under 313 of the code would be wholly unnecessary and improper. In such a situation, the accused cannot be questioned and his answer cannot be used to supply the gap left by the prosecution, left by witnesses in the evidence. So this question was never put. That's why, man, after 5 months, when the prosecution realized, for realization, they took 5 months, man, not immediate.
The
They
incident
further-
that taken place in the village, Vittoshara market is in the village. Vittoshara market is located in the village of the FLN?
No, village is different, market is different.
Different, man.
He was there found in the market,
Yes.
a drain in the market. That's why he is known as something else in that market area. He is known as something else in his village.
Yes. And that is only a nickname, my lord. Nickname, not the actual identity of a assailant. Assailant Doya is not that, my lord. They have not asserted.
Burden is upon them.
No, burden cannot be, my lord. It's always upon the prosecution.
Prosecution proof.
Prosecution, when failed to prove that, they have, my lord, come with that another context of 313, my lord. Inculpatory part saying Doya as dying. That cannot be, my lord, as per this judgment. It is only, my lord, inculpatory part cannot be the basis for sole conviction, my lord.
We have understood your son.
Yes, that is one.
Now
thing, my
burden is upon the court now
lord. Yes. Lordship.
to analyze and
My lord, thing
come to a
is-
finding.
my lord, thing is that, my lord, the identity of the person should be a complete identity. Section 9 Evidence Act is a relevant fact, identity of person. So relevant fact cannot be a nickname, my lord. The name of the full name, his father name, address, everything has to be. One has to be familiar with a person, so he should know by his father name, my lord. Generally in village, my lord, father names are known. Oh, he is the son of so and so. This is the thing, my lord. But he says, I identify him as Doya. But he do not know PW1 in cross-examination lordship. My friend has written the examination sheet, but the cross-examination part has to be read in detail, my lord. So that is the thing, my lord. And after 4 years, it casts a specific doubt. Because this has to be actually a basis of the dying declaration, my lord. Does not reliable.
Person will not give a dying declaration, will not die, might not giving postal address.
Not posted, father name.
In fact, we as a normally, we perhaps don't know a lot of parents' name or lot of our friends' name properly.
And on,
That cannot be expected from everyone.
my lord, that earlier judgment on identification I have placed yesterday, 2009 6 SCC. Identification for the first time in court is inherently weak. That is paragraph 19, 18, 19, 20, 21 and 26. 2009 6 SCC, page 748. So these things are lordship.
Yesterday you said 17 to 21.
Yes, my lord, I have marked the,
Today you have increased more
no,
from
up to
16 to 22.
26. my lord. Conclusion, my lord. Conclusion, my lord. The last submission would be, my lord, after this. Delay in recording the 161 statement. Although he was present in his village, my lord, and in such a condition, he was at home, my lord, but did not go for the lodging of FIR. Kindly see, very next day, my lord, PW1 say they went to the house of the, my lord, the informant and found the victim. And he was in a state to submit also. But in spite of that, my lord, they did not lodge the FIR. So very from the beginning of the criminal law, when it was set in motion, the things were very suspicious and they have improved, my lord. Entire evidence, my lord. And for that, my lord, innocent person, my lord, should not be, my lord, punished, my lord. My humble submission.
Okay.
He is a dining Pudait. It is a comprehensive, my lord, dining Pudait. He cannot be linked with the SLN dia, my lord. There is a big gap, my lord. So that gap prosecution has to fill up, my lord. When dying declaration also, sorry, 161 statement of victim also does not say is that he is the dining or son of so and so. So basically on presumption they have proceeded and DW is there.
Yeah,
Two of them, page 25.
They could have brought the Kudaite is the son of so and so.
And they have given, my lord, this,
Anyway,
in the search sheet also, my lord. Police has mentioned the father name. In 313 also, my lord, I have signed as Tiny Singh. Right. The lordship will see page 41, my lord. My father name is there.
page 41 of the page.
Page 41 of paper.
39 also.
41.
39 also.
Yes.
41 also.
39 also, I'm sorry.
Here.
This is clearly, my lord, stated. Father name is Kumzel Udaiti. My home is at village P. His village is, my lord, P. Ram Chang.
Mm.
I have replied, mother, I am innocent, I have not committed murder, that is what we have stated.
They belong to the.
Yes, my lord.
It is-
Two, three counts, my lord. One point of law. My lord, the whole controversy here, my lord,
Mm.
whether, my lord, this Daya and dancing Pudati, my lord,
Mm.
is one and same person.
Mm.
And my lord, whether the prosecution has proved
Mm.
that the Daya and my lord, the dancing Pudati
Mm.
is one and same person. That is the whole question, my lord.
Mm.
Your lordship will have to decide.
Mm.
And that is the case of the, my lord, the accused before this honorable court. The other things are not come, my lord, because that is not their case. The only thing, whether Daya is, my lord, dancing Kudati or not. Now, if your lordship pleases to see, my lord, the materials on record. My lord, first of all, I'll take your lordship, my lord, the paper book. PW1. My lord, what has happened? This, my lord, the victim, deceased, as well as the, my lord, the accused, they are same villagers. They know each other, my lord, prior to the incident.
Mr. Counsel, how long will you take to complete your submission?
Half an hour.
Basically, the PP is submitted. I think you basically you'll be relying upon what is submitted.
My lord, only thing, my lord, PW1, I think my learned friend has pointed out. PW1, my lord, he said, I know my lord, the accused in the dock, he has identified. My lord, he is Daya. Prior to the, my lord, the incident that has been taken place, my lord, they knew each other. My lord, he was known as Daya. This is number one, my lord. PW3 also, my lord, says so. My lord, this has been corroborated, my lord, by the accused himself in his, my lord, statement, my lord, recorded under.
See, Mr. Counsel, we'll do one thing. You please wind up within 10 minutes. Because all the witnesses we have already read.
My lord.
You just point out what are the relevant thing which according to you should be taken into consideration by this court. That's all.
Fine.
The reading is not required.
Your lordship directly come to, my lord. This DW1, my lord, here 313.
DW1.
My lord,
DW1.
lord, page 39. Question number 1.4.
This is 313. 1.4.
This is under 313, my lord.
Yes,
The
313.
question was put, is your nickname as Doya in your village? Now, my lord, the answer given by the accused himself. People of the Ditokchera is the village, my lord. Ditokchera market used to call me as Daya. Now, my lord, he himself admitted. It is his own admission, my lord. Therefore, my lord, the facts admitted need not be proved. Section 58 of the Evidence Act, your lordship. However, my lord, the prosecution has proved, my lord, successfully established the charges against the accused person, my lord, under section 341, 302 IPC. How? By deposition of PW1, PW3, my lord, coupled with 313 of the statement of the accused, my lord, that I have read out just now. My lord, the medical evidence of PW8 and corroboration by PW7, my lord, investigating officer. They have also deposed, my lord. My lord, that Daya and Dancing Udati is one and same person.
Where?
My lord, PW8, your lordship will find.
Page 18.
Yes.
This is IO.
IO, my lord. It is not a fact, my lord, the cross-examination part your lordship will find. It is not a fact that the victim and the witnesses did not state the name of the accused person as Dan Singh Padauti. It is not a fact that there cannot be more than one Daya Hamar in the locality. It is not a fact that Daya Hamar is not involved in the incidents. He is not the person named by the victim and the witnesses of the accused is innocent. So, my lord, PW1, PW3 and the IO has corroborated the, my lord, the fact that Daya and Dan Singh Pudati is one and same person. And my lord, in the village, my lord, generally the people know by nickname, my lord, not the original name of the person, my lord. Not their name of the parents. Now, the other witnesses, my lord, also says
Yes, Mr. Counsel will consider and
my lord, this,
close the matter.
yes. Then, my lord, your lordship kindly see, my lord, the impugned judgment. Judgment, my lord, page
47.
27,
No, 47. Judgment is at page 47.
47. No, my lord, relevant page, my lord.
It cannot be 27 when the page starts from 47.
No, my lord, page 69.
Yes, 69.
Page 69, my lord, 27.1. Para. In the instant case, while the deceased made his statement under section 161 CRPC before PW 8, the injured was alive and the injured person was not under expectation to death. The injured person received treatment initially at Swenso Hospital, thereafter the Silchar Medical College and then Gauhati Medical College, but the injured did not recover, ultimately succumbed to his injuries. The statement of the injured later on deceased is relevant, admissible as evidence. Well, where the victim knew assailants and gave her names, his names in the family members at first opportunity. His dying declaration could be relied upon. Well, this is important. Because fact remains, Miller, that subsequently he died. Therefore, this, my lord, statement recorded under 161, although it is not executed, my lord, has bearing, my lord, on the case. Because, my lord, subsequently he died and this, my lord, statement has been taken as dying declaration, my lord. In view of the judgment that has been rendered, my lord, Prakash versus State of Madhya Pradesh, CIR 1993, which has been indicated in the judgment itself.
Okay. All right, we'll close it. The counsel. Please
Let
write.
my lord, 27.7, last paragraph. 27.7. On perusal and evidence of from the prosecution side as well as the defense side, 27.7.
Yes,
and
read.
page 73. From perusal of the evidence from prosecution side as well as the defense side, it is found that prosecution has proved the charge against the accused, Dan Singh Padauti, alias Daya, under section 341, 302 IPC, beyond reasonable doubt. This is important. Whether the prosecution has proved.
No, for us, the issue would be to look for the evidence to indicate that what are the evidence when we write the judgment.
Well,
That this Kudaite is there.
absolutely.
But just this line is not enough. That charge is proved against so and so alias there. Why alias? What is
Well,
the
that is
evidence
supported
that
by
is
the-
alias?
Yes,
That
my
is
lord,
the issue.
that is
will be our challenge.
my lord, that is supported in my respectful submission, my lord. That is supported by this finding, is supported by the materials and evidence on record. My lord, that is my respectful.
right.
PW1, PW3, PW8, PW9, my lord.
Okay, we consider that.
My lord,
This judgment is under challenge. So for us, we have to consider everything.
my lord. My respectful submission would be, my lord, that my brother, who has been brutally murdered, my lord, in this incident, my lord, by the accused person, my lord, they are not, my lord, deserve any mercy or, my lord, leniency from this honorable court. Therefore, my respectful submission, my lord, that the prosecution has, my lord, the case is found established, my lord, by the prosecution. Prosecution has my lord, proved the case, and my lord, it is proved that the Daya and the Daya is the nickname of Dancing Pudati, my lord, and this Dancing Pudati and Daya is one and same person who has been, my lord, who has killed my brother, my lord. That is my respectful submission.
All right, please write down. Art Mr. B. Barwa, learned counsel for the appellant. Mr. R. Kaushik, learned additional public prosecutor for the state. And Mr. B.K. Shen, learned counsel for respondent number 2. Hearings completed. Judgment reserved.
My lord, on the point of TIP, my lord, I will place one judgment, my lord,
Obligation.
on the point of.
Yes, if you can give.
Item number 26. Lord, I need some time, my lord. Can I have it on 9th, my lord? 9th of March.
March
Yes, my lord.
20.
26, my lord, item number.
You're Mr. S. Kataki. Okay, other side,
I,
any objection? On the prayer of Mr. S. Kataki, learned counsel for the petitioner, matter stands adjourned. We'll state again on 9th of March.
my lord.
May I please, your lordship, I beg to make a mention for item number 25 of the daily list.
Yes,
Your lordship, similar matter was listed before a different bench today. The same was adjourned and has been directed to be listed on 25th of February. I pray that this matter may be tagged along with the repetition.
case number,
240 of 2026 WPC.
you're for the petitioner,
Yes, your lordship.
good name,
NN Datta.
as prayed for by Mr. N. Datta, learned counsel for the petitioner, the matter stands adjourned. To be listed
25th of February.
along with WPC number 240 of 2026,
Okay.
which he submits that is a similar matter. Date is not required.
No.
Once it's connected, it'll come.
Obliged.
My lord, I beg to mention item number 24, my lord. I have some difficulty today. I have taken consent of the other side, my lord. Maybe adjourned for the day only.
You're for the,
Petitioner.
okay. Mr. J. Sharma,
Yes, ma'am.
counsel for the petitioner submits that he has some personal difficulties to conduct the case today. And prays for adjournment. As prayed for, matter stands adjourned. We will state again.
R. Gogoi, Setting Council Forest.
When do you want it?
Yeah.
My lord,
2 weeks?
any day convenient to the honorable. First week of
10 March.
10 March.
We will state again 10 March.
Right.
Mr. R. Gogoi, learned counsel, appears for the
Forest Department.
Forest Department.
Yes, please, Lord. My lord, I beg to mention item number 22, my lord. In
Yes,
this case, my lord, some notices were under silence and subsequently those notices were withdrawn. And between the parties, it is compromise settled, my lord. As such, my lord, matter is infractious.
your good name?
So it may be closed.
Your good name?
K.U. Ahmed.
Mr. K.U. Ahmed, learned counsel for the petitioners, submits that during the pendency of the writ petition, the parties have come to a compromise and therefore cause of action does not survive. Anyone appearing for the other side? Miss Udas, additional senior government advocate, appears for the state respondents. In view of above, writ petition stands disposed of.
Obliged.
Has he come?
Yes.
Mr. S. Datta, learned counsel, appears for the PNRD department.
Obliged.
Yes.
May it please your lordship. I beg to mention item number 23 up to this case.
Hmm.
Yesterday, your lordship, we have filed a reply. I'm for the petitioner.
Hmm.
So let time be given for, let the matter be adjourned. Lordship.
Learned counsel for the petitioner, Mr.
My name is A. Narzari, your lordship.
A. Narzari, submits that reply affidavit has been filed by the petitioner just yesterday. Mr. Abedi, seen that the same is not yet on record. Office to verify and connect the same to the record and list the matter again after 2 weeks.
At your convenience, your lordship.
2 weeks? On a date to be fixed by the registry.
First week of March, your lordship.
They'll give you a date. Okay.
10th of March. your lordship.
Registry will fix a date. Yes, next. Anyone?
For withdrawal item 30 of the supplementary list.
My lord, order has been complied with.
Mr. A.H.M.R. Chaudhary, learned counsel for the petitioner, submits that the direction of this court has been complied with. Mr. Arbor Pujari, learned counsel, appears for the sole respondent and agrees to the submission. In view of above, the contempt petition stands closed.
Item 1 promotion.
But in this case, my lord, I was supposed to get instruction. I have sent for instruction, my lord, I cannot get it back. Can it be fixed after 2 weeks, my lord?
Yes. Mr. J. Payang, learned counsel, appearing for the
Standing counsel for the FT and border matters.
learned standing counsel FT and border, submits that he needs some more time to receive instructions in the matter. As paid for further 2 weeks time is granted. List again on so and so.
7th March.
Right.
Item 2.
Make this lordship. Lordship, payment regarding, lordship, matter regarding non-payment of higher charge, my lord. Lordship, we have a petition filed on 3/1/26, my lord, regarding admitted amount, my lord. Lordship, see, page number 31. It is a file.
Amount is not admitted as stated by him, lordship.
Where is the amount? This is an order,
Yes, my lord.
Yes.
page 32.
Page 31, my lord, serial number 8. The higher charge shall be paid on submission of bills and duplicate on
So what is,
completion of the duty for which the vehicle is hired. The bill shall be forwarded to concerned SPS for payment.
These are order, lordship. So first occasion, he was supposed to bring on record the acknowledgement of bills from the head of the department also.
yes, Mr. Counsel, this is an order saying that this is the hire for vehicle of hiring this vehicle. Your whole case is that it is an admitted liability. So court say that if it's an admitted liability, show us a document by which they have admitted your claim. So you file an additional affidavit. In the additional affidavit, now you annex an order.
Lordship, see place number 16, my lord. It must be there, my lord.
Huh?
Like 16, and is it 2?
16.
Yes, my lord.
This was already perused by the
They have
court.
reached, my lord.
What is this?
Must be in the top corner. They have reached, my lord.
No, that is okay. This is your bill. Now question is the admission of the respondent that yes, we owe you this much. Any document like that?
Lordship, but now they are not taking any action, my lord. That's why I file a
Not taking an action is a different thing. What to do? We issue notice. You take instructions.
notice. May be
At this stage.
Heard, Mr.
A. Hussain.
A. Hussain, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities concerned to release the admissible amount of money payable to the petitioner, which is to the tune of 928,340. Towards hiring of vehicle. So the learned counsel submits that it is the case of the petitioner that the respondents have admitted to their liability for payment of the said amount. So on 21/1/2026, when the matter was taken up, the petitioner was asked to file an additional affidavit showing the acknowledgement of the liability of the aforesaid amount. So the petitioner has no doubt filed an affidavit, but enclosed with the same is only an order by which the vehicles have been hired. So be that as it may, let notice of motion be issued, returnable by 4 weeks, Mr.
S.R. Burwa for all
S.S.
respondents.
Barua, learned counsel. Accept notice on behalf of all the respondents. Which department is this? You're for the transport.
Home Department, Lordship.
You are the government advocate.
Yes, government employee.
Mr. S.S. Barua, learned government
Yes, sir.
advocate. Accept notice on behalf of
All the respondents, Lordship. From respondent number 1 to 8.
all the respondents. As such, no formal notice is required to them. Petitioner shall however furnish requisite copies of the writ petition to the learned government advocate within 2 days. Next para, pendency of the writ petition shall not be a bar for the respondents to mitigate the grievance of the petition.
Item 3,
But the connected petition was filed for recovery of a non-payment of contractual dues.
This is disposed,
Yeah, it was disposed, my lord.
order dated 13/6.
Yes, my lord. Specific direction was given to release the balance payment of 30% within a period of 3 months. So,
Keep,
And you have served a copy. Have you served a copy of the order?
not yet. A copy of the order, yes, I have served. They have
When?
released the part payment of the particular amount of.
Sorry?
They have released
Part payment only.
yes, my lord. Out of 13 lakhs, they have released around 9 lakhs 64,000. The balance payments.
How much is the total amount?
Total amount was, my lord, 13 lakhs 66,594.
Okay, they released 9 lakhs.
They have released 9 lakhs 52,924.
Hmm.
The balance 4 lakhs 13,670. Left, my lord.
Who is the respondent
Rest of it. Chief engineer, my lord.
of?
The chief engineer of GMC Waterworks Department and the executive engineer,
Two respondents.
2 respondents. And in fact, they have conceded to my I had quantified the amount in the petition, they had considered to that amount also. It is reflected in the order now.
Heard Mr.
Eight account.
A. Dekha, learned counsel for the petitioner, who submits that the order of this court dated 13/6/2025, passed in WPC number 1872 of 2025, has not been complied with by the respondents. And therefore, the contempt by the respondents, despite a copy of the same having been furnished to them. Stop. He, however, submits that there has been only partial compliance of the order, with balance amount pending to be paid. Next para, in view of above, issue notice returnable by 3 weeks. Petitioner to take steps for service of notice upon the respondents by speed post within 3 days. List the matter again on so and so.
Item 4,
May I please your lordship?
Yes.
Lordship, the petitioner, before your lordship, was awarded a work contract for construction of toilet. Lordship will kindly see annexure 3 at page 29.
Yes. What about the other side?
My lord, we have filed our affidavit today.
When? Today?
Today, my lord, it's not on record. We have brought out detailed annexures, my lord.
Let it come up then.
Yes, my lord. Next.
Lordship.
You have received a copy?
The last order.
You have received a copy?
Yes, just now. Lordship, may kindly see the last order.
I've seen it. That's why I'm asking you about the affidavit. Did it come up on Monday or Tuesday?
My lord. There's-
Monday.
There's already a stay on the recovery. We're not.
I understand. That's why.
The other aspect.
Let the affidavit be on the record.
My lord.
Please write, in terms of the last court's order dated 4/2/2026, the respondents have filed their counter affidavit this morning. Top, the same is yet to be tagged on the record, registry to verify and tag the same to the record. List the matter again on 18/2/2026.
Much obliged.
Interim order passed earlier shall continue. Till then.
Well, here is, in this case, my lord, the petitioner participated in a tender process, my lord. My lord, this bid has not yet been opened, my lord. Although, my lord, it was supposed to be opened by 7/10/2025.
7/10/25.
Yes, my lord.
Where is the NIT?
Page 18, my lord, kindly come.
18.
18.
18 is the schedule,
Well, time schedule.
a time schedule. You show me the schedule. You show me the NIT, the beginning of NIT. Annexure A, I think page 13.
Yes.
Is pertaining to what? Pertaining to
NIT, this is the NIT, my lord.
serial number.
Serial number, my lord.
You're concerned with serial number
27, my lord.
27.
Yes,
Water Resource Department.
yes,
27.
yes,
Construction of embankment.
yes,
This one
yes,
at page 15.
15, my lord.
Last date for submission of bid is 19/9. Date and time of bid opening is 19/9.
My lord, time schedule.
Bid will be in 2 stages.
Page 18, my lord.
Technical and financial bid.
Not even technical bid also.
What is the stages?
My lord, now they have kept this bid, my lord, intact, my lord. In fact, my lord, other bids, my lord, of the other packages have already opened, my lord.
27 is not yet open.
Yes, my lord.
Any representation?
27 and 28 was not open, but 28, my lord, pertains to another inspection that is pending, my lord. That posted day before yesterday, my lord. WPC number 701, my lord. Wherein notice was also issued, my lord. 701 WPC number.
701.
Yes, my lord.
26.
26,
Will issue notice then?
my lord. And tagged along with the-
Hard Mr.
Yes, sir.
S. Hawk Learned Counsel for the petitioner, who submits that the grievance of the petitioner is non-opening of the tender in respect of serial number 27. Not serial, in respect of item number 27 in the NIT dated 26/8/2025, bracket annexure A. Top, the Learned Counsel submits that although the bid was to be opened on 19/9/2025, the same has not been opened till date by the respondent authorities concerned for reasons not known to the petitioner. Next para. In view of above, issue notice of motion returnable by that case. What happened?
Fixed matter on, along with WBC number 701 of 2026.
Notice was issued.
Yes, madam.
Returnable by
It was open 20, madam. 20 of February, madam. 701.
20th of February. Next week. Yeah, we got it. Kim. What is the returnable date?
25.
Returnable by 25/2/2026.
Right.
No, you make it returnable by 2 weeks. Miss
PCA,
PCM,
CA,
CA, given writing,
SEYIE.
SEYIA. Learned Counsel accepts notice on behalf of
All the respondents.
all the respondents. As such, no formal notice is required. Petitioner shall, however, furnish requisite copies of the writ petition
Right.
to the learned Standing Counsel, Water Resource Department within 3 days.
Your Lordship, actually, the petition copy that we have received, there's a lot of missing pages, so we're not able to, we won't be able to.
Please rectify.
Right.
I'll not indicate in the order, but please rectify,
Right.
okay? Whatever he have filed, same copy should go to
Yes,
them.
yes.
Next para, it is submitted that a similar writ petition, that is WPC number 701 of 2026, is also pending. Stop, as paid for, let this matter be listed along with WPC number 701 of 2026.
Right. I'm obliged.
Item 6.
This relates to non-payment of some payment against some supply matter. Supply of hand sanitizer and hand sanitizer. Hand sanitizer in during the period of COVID-19 pandemic matter. But if we'll see the
How much?
pending amount is 1,96,72,000. He supplied an hand sanitizer for an amount of rupees 1,97,12,000. 40,000 has been paid to him.
40,000
Only 40,000.
out of this 1 crore,
Yes, madam. So
almost
Lordship,
2 crores.
if your Lordship sees the annexure 8 page 25 last page, madam. It stated that Karbi Anglong Autonomous Council Dipu is liable to pay the bill. He submitted an RTI application. Application is at page 24. In response to that application, madam.
KASC is a party.
Yes,
You made them a party.
yes, madam.
So
Respondent number 4, madam.
your claim for payment has been diverted to KASC.
Yes.
Case is not made a party, man.
Not made a party?
Not made a party.
Respondent number 4, madam.
KSC, man, Karbi Anglong Autonomous Council is constituted under the 6th schedule of the Constitution of India. What my lord, that should be the.
Respondent number 3, madam.
He is the official, my lord, only the official, man. He can. Lord, so anyway, notice maybe issued will take that point, my lord. And there is a decision of the Supreme Court, my lord, without making the party, my lord, necessary party, my lord.
What according to you be the necessary, I mean, with the proper party?
Without Karbi Anglong Autonomous Council.
No, that I understood. That I've understood. What would be the nomenclature according to
Karbi
you?
Anglong Autonomous Council, my lord, and it is represented by the principal secretary, and that is the constitutional authority, my lord. And that should be the party, my lord.
Take note of
Yes,
that.
yes, madam. Let me file and madam.
KAC
Yes.
represented by the principal secretary,
By
like that.
Principal Secretary Dipu, my lord. He should file.
Like State of Assam
Yes, yes,
represented
I'll
by
file.
chief secretary, like that.
My lord, like that, my lord.
Ah.
And there is a decision, my lord, that point has been decided, my lord, without making the party, my lord, the petition is not maintainable. I'll take the plea in the affidavit of question if they have not made the party. Now I am accepting notice on behalf of respondent number 5.
5 only.
Only
Yes.
5, my lord.
Let me file and madam. IA, madam.
3 you cannot accept over.
3, my lord, government, 3, my lord, 3 and 5.
Okay. heard Mr.
NK Kolika.
N.K. Kolita, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities concerned to pay the outstanding bill amounting to rupees 196,72,000 within a stipulated time. Full stop. The learned counsel submits that the said amount is towards supply of hand sanitizer during the COVID times. Stop. The learned counsel submits that on submitting an RTI application before the health department, the petitioner has been informed that the amount should be paid by the Karbi Anglong Autonomous Council. Stop. In this connection, he has drawn attention of this court to an extra rate of the writ petition. Next para, in view of above, issue notice of motion returnable by 4 weeks. Government, who will appear? State government? Miss T. Bora.
P. Bora on behalf of P. Bora. One.
Miss B. Bora, learned counsel accepts notice on behalf of Mr. D. Upamanya, learned standing counsel, health department, who represents respondent numbers 1, 2, and 4.
I've got 3 and 5.
And Mr.
Yes, yeah.
J. Sufia, learned standing counsel, KAC, accept notice on behalf of respondent numbers 3 and 5.
Okay.
Petitioner to take steps for service of notice upon respondent number 6 by speed post within 3 days. Extra copies of the writ petition be furnished to the learned counsels appearing for the respondents today within 3 days. List again on so and so.
Lordship may observe that
Tendency of the writ petition will not be a bar for the respondents to mitigate the grievance of the petitioner. All right.
7.
My pleasure, Lordship. Lordship, in this writ petition, I have a very limited period to dispose of my pending representation, my lord. That the matter related to deletion of name of my voter list, my name is there.
Where is your representation?
My lord, my representation is 44, your lord.
44.
45, your lordship. Annexure 11.
When did you file this?
On 19/12/2000.
1912.
Let them dispose of my record is with them, my lord.
Well, in this case, let me get instruction, because this, my lord, as per my learned friend, my lord petition, he was declared to be for, my lord, his name has been deleted, marked as D in 2005 itself.
So let them dispose of
We
the
begin
matter, my
2005.
lord. Liberty is always with you. Let them take a decision.
And secondly, my lord, in similar circumstances, this honorable court has disposed some matters, my lord. In that line, your lordship may dispose, if your lordship.
How is it disposed?
Disposes, my lord, is the matter is sent to the SP border of the concerned district to verify whether his name has been referred to the foreigners tribunal or not. If not referred, they may be referred. If referred, my lord, he may be informed that yes, a case has been referred against you. If there is any decision, he may be communicated. That must. And if there is no, my lord, reference, then he has to be referred to the foreigners tribunal, because once D has been put by the electoral committee, ECI, my lord, nobody, ERO, nobody can remove that, my lord, D marks until and unless it is determined by the foreigners tribunal.
Who has kept this D voter? He declared him D voter?
It's by ERO, my lord. Electoral registration of ERO.
ERO. ERO comes under?
Election Commission of India. Say, as these were done, my lord, as per the direction of Election Commission of India in 1997 and 2004. Extensive revision, intensive revision of the voter list were done. And during that time, my lord, those names whose names were doubtful, they were put under D marks. Then those matters were sent to the foreigners tribunal for determination. Once it is determined, if he is found to be Indian, his name will continue.
And if his name is found to be, he is found to be foreign,
ERO full form,
electoral registration officer.
electoral.
Yes.
I want to show one, my lord, the voter list, my lord, page 36, 1997, my lord. My name is there, my lord. And my lord, my name is deleted, my lord, without my inform me, my lord. It is, my lord, violation of national justice, my lord. Page 36, lordship.
So in that manner, if your lordship.
In our page is 36, my lord.
Furnish some similar.
Serial number 174, Zaharuddin, my lord. My name is there, my lord. All of a sudden in 2005 list, my lord, my name is D, my lord. And without inform me, my lord. I am not aware about that, my lord. So that is why, my lord, the authority has deleted my name marked as D, my lord. So let them take a decision, my lord.
When did you come to know about this?
My lord, very recently, my lord. When the SR is going on, my lord, then I come to know, my lord.
But
This is
you have been declared as D voter in the year 2005.
I am not aware, my lord. That
20
is the
years.
issue, my lord.
More than
Yes,
20 years.
my lord. They are not also informed me, my lord. If they inform my lord, then I came to know, my lord. Only SR is going on informed of, my lord, is for recent elections, my lord. 26, my lord. Then I come to know my name is Marcus D, my lord.
Once his name is put D, my lord, he cannot cast vote, my lord. He's debarred from casting vote. That means he has not casted vote since 2005.
My lord, anyway, my lord. So let them take a decision, my lord. Or
So if your lordship want to dispose of, I can supply, my lord, similar order, my lord. In that manner, your lordship may dispose of.
Council, we can dispose it of like that.
But lord, in the light of but my prayer is, my lord, everything my fathers gave voter list to 1966. Thereafter onwards, my lord, 85, all those, my father's name is there.
That they will
My
consider.
brother's name is there. So, my lord, that
So
is
those are the matters which will be considered by
By
them,
the tribunal, my lord.
but not by this court like that.
That is. So,
my lord, my prayer is to dispose of my pending representation. Everything is there, my lord.
if that is there, my lord, if his name, my lord, there is, it may be such a situation that he may be declared already foreigner. He may be a declared foreigner also, we don't know, until and unless we get the instruction. That's why, but the matter may be sent back to the SP concerned. He will make an inquiry. If any reference is sent to the foreigners tribunal, he will be informed. If he has already been declared to be foreigner.
Similar orders have been passed.
Yes,
Isn't it? Give me that.
Yes,
Let's see.
we'll furnish, my lord, two books. The lordship may dispose of them, that, I'll furnish, sir. As of now, I don't have much.
Okay, Tambi.
Yes, I'll provide.
Item 8.
That will be lodged. Petitioner before lordships, they have formed a society and it is registered under the Societies Act. They are unemployed youth and they purchase a plot of land and set up a private market on that particular land. Now, my lord, they are continuing, but all of a sudden, page 31, another 7, this private land, our land has been settled with the respondent number 7.
Sonawar Hussain.
My lord,
Is respond number 7.
respond number 7. It is stated that it is under 107 of the Panchayat Act. Your lordship kindly see 107 of the Panchayat Act. I have, my lord. Page 10, I have quoted that provision of section 107.
Yes, just read.
My lord, paragraph 7, no private herds and fisheries shall be allowed to operate with the area under the jurisdiction of a Gaon Panchayat without prior approval of the concerned Panchayat authorities and government. The Panchayat shall impose such fees as may be prescribed. On the basis of that settlement has been made to the other person who is not the owner of that particular private herd.
Who has issued this order?
My
I
lord,
mean,
it
the
is-
settlement.
That's it, Jila Parishad.
Jila Parishad.
Jila Parishad. Chief Executive Officer, Jila Parishad. And I'm paying the license fee also, I have annex, and that is, my lord, is 27. Oh, sorry. That is page 30. And it is valid up to October 2026. And it is our land, it is private property.
So this land belongs to you,
Minor. By
and you're running a
Yes. Market.
market.
It, of course, it is a private market. It is also admitted in.
It's a private market.
Private market.
And the Zilla Parishad has awarded, has settled the market with respond number 7.
Minor.
Can that be done in such a manner?
Minor.
Yes.
That's it, kindly see page number 30. There written, the name of the, in license, the name of the bazaar is Kosumara Andabhanga Maharsara Bazar Anshalik Unnayan Samiti. But Lordship, we have the settlement order, the name of the market is, kindly see Annexure 7, page number 21. The name of the market is
Different or what?
different, Lordship.
It is the Samiti petitioner.
First, Lordship, will take instructions. There is same or another market.
Name same.
No,
No, Lordship, different.
same matter. It is the Samiti is the petitioner.
And the name of the bazaar is Kosumara Andabhanga
Sir, Bazaar.
Bazaar with cattle market.
It is the market name, market's name, and petitioner is a society that is.
But the license name is different. So for that purpose, we'll take instructions.
Now, under private heart can be settled to the other person.
So now that's in notice.
That under 107. That is my case.
They've
Yes,
invoked 107.
Yes.
Okay, 107, yes.
We are running the market now, all of a sudden.
What is the position as of today?
Now, my lord, there's some chaotic condition. We are running and they also
Running.
trying to, my lord.
Both parties are running.
Both are disturbed.
Become a very big market now. No?
Possibly 10 lakhs rupees, my lord, per year. Possibly, I don't know.
For that purpose, notice make a budget now.
That Unnayan Samiti is the owner of that particular bazaar.
Where's the 11 provision you have abstracted? Page?
That 107.
Yes.
It is page 10,
Page 10.
paragraph 7.
Heard Mr.
And how?
N. Hawk Learned Counsel for the petitioner. Petitioners. Who submits that petition number 1 is a registered society under the Societies Registration Act. Have you? having a certain plot of land in village Machera under Bagori Bari, Moza, in the district of Borpeta. The petitioner society has been running a private hut bracket market in the said plot of land. And while such is the position, the chief executive officer, Borpeta Zira Parishad, White, the impugned letter dated 30/1/2026, has settled the Kachumara Anda Bhanga Manchera Bazaar with cattle market for the year 2025-26 in favor of respondent number 7, purportedly under section 107 of the Assam Panchayat Amendment Act 2023. The Learned Council submits that under the said provision, private huts with prior approval of the concerned panchayat authorities and government is permissible, and that the respondent panchayat is not empowered to allot or settle private hut in favor of any other party. So, he therefore summons that settlement made in favor of respondent number 7 should be set aside. Next, para in view of above, issue notice of motion returnable by 3 weeks. Miss, your good name, please? N. Bora. Learned. Hmm.
For respondent number 1, 2, 3, and 6.
Council appears on behalf of respondent, accepts notice on behalf of respondent numbers 1,
1, 2, 3, and 6.
1, 2, 3, and 6. Mr. S.R. Barua, Learned Council, accepts notice on behalf of respondent numbers 4 and 5. Petitioner to take steps for service of notice upon respondent number 7 by registered post with by speed post within 3 days. Extra copies of the writ petition be furnished to the Learned Council's appearance for the respondents today within 3 days. Next para, also issue notice on the interim prayer made by the petitioner, returnable by. You want a date for the retrieve?
Right.
Interim?
They may be considered, while otherwise,
Also, in this notice maker will take instructions.
while prima facie it is illegal under section 107 private car. And our High Court's judgment, I have evidence also. That yes, private hut cannot be.
All right, returnable by 3 weeks as well. Councils for the respondents to obtain instructions by the next date. List again on so and so.
Till then, my lord, till then,
Till then what?
all of this order may be stayed.
Order is already in the month of January.
That is
We are in
correct.
February.
This correct.
Now, how do you say that?
Well, the problem is that we are also trying to operate the market. They are also trying to operate the market. That is the main problem. Can you see the judgment of this our High Court? I have annex also. It is page 42, para 17.
No, we'll do one thing. We'll have an early date for the interim thing, but not today. You get the instructions. When can you get the instructions? Insofar as interim is concerned. Felix, I've already said.
If for instruction, by next week, they can obtain instruction on no problem. Next week, any day. It is today's Friday. By next Friday, they can obtain instruction.
That's it, kindly fix them 23.
23.
23.
Okay. Please the matter on 23. To consider for consideration of the interim prayer. Okay.
That's it, kindly provide the extra.
Yeah, I've already said that.
Yes.
May I, your lordship? Such a matter pertains to non-payment of contractor bill and page 16 is the liability statement, lordship. It's admitted and part payment already done, lordship.
How much done? How much paid?
Lordship, total was 2,89,824, out of which 1,73,000 already paid, lordship, leaving a balance amount of 1,16,500.
Yes. Ms. Gayan?
Similar case notice has already been issued,
Similar, lordship, similar case already disposed of, lordship.
ma'am.
Lordship may dispose of directing them to verify and
Pay within time frame.
After disposing lots of case again comes before the court,
This is liability towards what?
But we are only, we don't have so much of part as per court, respondent number 1 and 2, that has to be given by respondent number 3, 4, 5, water issues department.
You are for?
And for 1 and 2.
1 and 2. So who will pay this amount?
lordship, it's the
Water 4, 5, water issues department.
Yes. Instruction. What instructions? You can very well verify and pay up the money if they.
It's already
Yes.
admitted, lordship, part payment already done. Let him verify if the petitioner is entitled.
Amount is also not much, 1,16,000.
Lordship, its amount is also not much.
Heard Miss
K.K. Chaudhary.
K.K. Chaudhary, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks for a direction for payment of
Balance.
the balance amount of rupees 116,504
Lordship.
by the respondent authorities concerned for completion of the work undertaken by the petitioner. Top C, referring to the liability statement at annexure 1 to the writ petition, the learned counsel submits that the total bill value was for rupees 289824, and out of which an amount of rupees 173320 had already been paid. When was it paid?
Lordship, it don't mention the date.
And leaving a balance of rupees 116504. Stop. The learned counsel submits that since the same is an admitted liability, the respondents may be directed to pay the same within a time frame. Next para, Ms. A. Gayan, learned CGC.
For 1 and 2,
Appears for respondent numbers 1 and 2. And submits that the amount will have to be paid by the Water Resources Department, if at all there is any such liability. Your good name, Miss PCA, Learned Counsel for respondent numbers 3 to 5, submits that she may be given some time to obtain instructions from the Water Resources Department to see as to whether there is any such pending liability. Stop. However, considering the fact that the liability statement has been prepared by the department themselves through their officials, this court is inclined to dispose of this petition with a direction to respondent authorities to verify the claim made by the petitioner as set out in annexure 1 of the writ petition. Stop. On such verification, if it is found that the balance amount of money which is projected in the statement is correct, the same shall be paid to the petitioner without delay. The entire exercise be completed within a period of 2 weeks. Are you sure?
2 months, Lordship, before 31st March.
Within a period of 2 months from the date of receipt of a certified copy of this order. See, your counsel for the petition have been fair. If you say 2 weeks, you'll be in trouble.
Obliged, Lordship. Lordship,
Okay.
11 is also similar matter.
PW 10.
11 is similar.
Similar matter, Lordship.
Just give me the 11.
11, I'm appearing for response number 3. I go to the
Aye, I will do. Here, Lordship, page 13 is the liability statement. It's an admitted amount, Lordship.
Okay, amount is not yet paid. Any amount is not paid. None of the amount paid. Part Ms. K.K. Chaudhary, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner prays for a direction to the respondent authorities concerned to pay the petitioner an amount of rupees 129,6267. Which is pending in favor of the petitioner for the work having been executed. So referring to the liability statement and close to the writ petition at Annexure 1, the learned counsel submits that the same is an admitted liability. And it has the certification of the responsible officers of the department concerned. That is the, what is this? Water Resources Department, Water Resources Division, Nagaon. Miss so-and-so, learned counsel appearing for the Water Resource Department, submits that she may be given some time to obtain instructions of the matter. While Mr.
Number 3, SR Borough.
S.R. Barua, learned government advocate, appearing for respondent number 3. What is your submission? Instruction also has the same prayer. Stop. However, considering the fact that the liability statement has been prepared by the officials of the Nagaon Water Resources Division, Nagaon, and duly certified and recommended by the additional chief engineer. This court is of the considered view that the writ petition can be disposed of at this stage by directing the respondent authorities to do the necessary verification as to whether such amount is pending as on date or not in favor of the petitioner. Expire. Accordingly, writ petition is disposed of by directing the respondent authorities, more particularly the respondent numbers, who will verify.
This is chief engineer. Executive engineer, maybe 6.
Respondent numbers 4 to 7 to verify the claim of the petitioner or payment of the admitted liability. Stop upon such verification, if it is found that the amount is due and pending in favor of the petitioner, the same shall be released to the petitioner without delay. Stop the entire exercise be carried out within a period of 2 months from the date of receipt of a certified copy of this order. Stop the petitioner shall also furnish a copy of the certified copy of also furnish a copy of the writ petition to the respondent number 4 along with a certified copy of this order for doing the needful. All right. 2 months.
Lordship, it should be before. Lordship, it should be before 31st.
Huh?
Issues forward the revenue department, revenue department will verify and pay. The time required.
Yeah, ultimately, it will come from the water resource department to the district commissioner, then district commissioner forward for the fund to the government revenue department, so it will take that. But can it be 4 months? now?
Not 4 months. 1, 2, 3 months. 3 months.
I'm a bit for.
Mr.
Yes, sir.
S. Dr. Learned Counsel appears for respondent number 2. All right.
Okay. Okay.
Being 7.
Yes. Know what? Oh, this is that matter. Where's the counsel?
I've furnished copies of 2 similar orders.
We can pass the same order.
Lordship.
Where's the counsel? He was here this morning. Where is the voter?
Lordship, annexure
207. Page?
page 37.
This, 37.
37. 37, 38.
It is as per the electoral roll of 2005.
Lordship.
No, where is the mark D?
Lordship, he hasn't produced those voter list here, Lordship. These are certified copies.
So how do you know that? How do we know that He's been marked as D voter.
Lordship, his intention is that he alleges that he's been marked D.
Your case is that you've been marked D voter. Where is that? Page 37 is the electoral roll of 2005.
Page 48, my lord, I have categorically stated in my representation, my lord.
The statement is there, no doubt. You make a statement also, orally also, okay, we accept. But is there any document to show that you have been marked as D voter?
But my lord,
How do you know? How did you come to know that you have been made marked as D voter?
my lord, for a moment. So,
Okay, anyway, similar orders have been passed. I have been given a copy. We'll dispose of in civil lies.
my lord.
Heard Mr.
K. Dashi.
K. Das, learned counsel for the petitioner, and Miss
S. Kataki,
S. Kataki for respondent number
respondent number 367.
36 and 7.
I'll respond. I'll take
Mr. D. Payang for respondent number
J fine for election.
J. Payang for
2 and 5 man.
D voter, that's why D. Payang. Mr. J. Payang for respondent number
2 and 5 man.
2 and 5. Mr. S. R. Barwa, learned counsel for respondent numbers 4. Respondent number 4. Stop having regard to the nature of controversy involved in the instant writ petition. The same is taken up for disposal at the motion stage itself. Next para, it's the case of the petitioner that he has been marked as D voter in the voter list of 2005 without giving him any opportunity of hearing. What is the constituency?
My lord,
Constituency?
Horbok, 40 Horbok.
Hmm.
Lordship will find it on page number 37.
The petitioner falls under the Sorbok 40 LAC. So the learned counsel for the petition submits that the limited prayer of the petitioner at this stage is for a direction to the electoral registration officer, Borpeta, to consider and dispose of representation filed by him on 19/12/2025. Bracket annexure 11. Stop learned counsels appearing for the opposite parties, on the other hand, submit that similar writ petitions have been disposed of by this court by directing the superintendent of police board concerned to verify as to whether such person marked as D voter has been referred to the foreigners tribunal for consideration. And therefore, the present case as well may be referred to the authority concerned. Since the same is to be determined by the concerned foreigners tribunal. Stop. Next para, considering the submission made. This court therefore directs the respondent number 5, that is the Superintendent of Police Border, Barpeta, to verify as to whether the petitioner has already been referred to the concerned foreigners tribunal. And if upon verification, it is found that the petitioner has not been referred to the concerned foreigners tribunal, respondent number 5 shall refer the case of the petitioner as regards the mark within inverted comma D, capital D, in the voter list in respect of 40 number Sorbog LAC to the competent foreigners tribunal, Baksa district, for an appropriate adjudication as regards the status of the petitioner as D voter in the concerned voter list. D again will be inverted comma. Next para. Reference be made within a period of 2 months from the date of receipt of a certified copy of this order. Stop upon such reference being made, the petitioner may participate in such proceedings and establish his case. Stop. If the case of the petitioner, as per the records, had already been referred to the relevant foreigners tribunal, there would be no requirement to make any further reference, and the detailed information of the earlier reference be communicated to the petitioner. With the above observation and direction, the instant writ petition stands disposed of.
Your lordship has mentioned the Baksa might have to. The Baksa may not be mentioned in the concern, by the way.
Baksa cancel, huh?
The concern.
My lord, another small prayer, my lord.
Yes.
Whatever the decision will be taken by this, my lord, respondent number 5, that should be communicated to me, my lord. Actually, my representation is pending before the respondent number 6, my lord. Whatever, my lord, that earlier the respondent number 5 was directed, is directed, my lord. So any decision, whatever taken, my lord.
It is also provided here in that any decision taken by the respondent number 5 be communicated to the petitioner.
Obliged.
Yes.
Right.
Item 10.
Please, your lordship.
Yes.
Lordship, in this case also pending bills at page 14. There is a liability statement.
How much? Page 10. Page 14.
Yes, 14.
How much is the amount?
It is pending amount is 3,25,000.
The total amount is how much?
Total amount was it is submitted 3,91,489. Out of that, 66,488 has been paid initially. So it is. This matter can be disposed of in my humble submission in the line of item 10 and.
Yes.
Lordship, we are humbly praying that notice may be issued so that we can get further instructions regarding this bill.
We will record your submission. You can very well verify. We're not saying that give them the money like that without verification. You will verify, and if they find that the amount is due,
Verified, they have paid.
there'll be further verification also. Hard Mr.
S.C. Das.
S.C. Das, learned counsel for the petitioner, and also Mr.
V. Keso. V. Keso. V. Keso.
V. Keso. K-H-E-S-O.
K-H-E-S-O-H.
K-H-E-S-O-H. V. Keso. Learned counsel for
All the response.
for all the respondents. Stop having regard to the nature of grievance projected by the petitioner in the instant writ petition. The writ petition is taken up for disposal at this stage itself. Stop. Next para. It is the case of the petitioner that. What kind of work did you do?
There is,
Okay, the petitioner had undertaken the work of anti-erosion measures
anti-erosion,
to protect the bank of
Puthimari River.
Puthimari River. Where is this place?
My lord,
Location.
location it is Kamru. There is no mention of, but Ronya area, that is Kamru.
Within the Kamrup Rural District.
Yes, my lord.
And the bill value amount of rupees 391,489 was generated. Now, although the petitioner had completed the entire work, but only amount of rupees 66,488 has been paid so far out of the total amount due. The learned counsel for the petitioner submits that the same is an admitted liability and the balance amount which remains to be paid is an amount of rupees 325,001, which can be seen from the statement of the outstanding liability made in favor of the petitioner by the officials of the Water Resources Department, which is annexed as Annexure 3 to the writ petition. The learned counsel therefore submits that the respondent authorities may be directed to pay the balance amount due to him within a time frame. Next, the learned counsel for the respondents, on the other hand, submits that he may be given some time to obtain instructions in the matter and to verify on the veracity of the claim made by the petitioner. It is, however, seen that the statements of outstanding liability has been certified by the departmental authorities themselves. And therefore, this court finds no impediment in disposing of the writ petition at this stage. Next, in view of above, the writ petition is disposed of with the direction to the respondent authorities concerned, more particularly respondent numbers 2 to 5, to verify the claim made by the petitioner for payment of the outstanding liability. And upon such verification, if it is found that the amount is indeed due to the petitioner, all necessary steps be taken to disburse the amount to the petitioner as expeditiously as possible, to stop the entire exercise be carried out within a period of 2 months.
2 months.
2 months from the date of receipt of a certified copy of this order. The petitioner shall also furnish the respondent number 2 a copy of this writ petition along with the certified copy of this order for the needful. Okay.
Item 12.
In this case, SC fishery is not a party matter, but in the cause list matter, our name is shown. Instead of
AFDC is there.
FCC is there.
No, Water Resources Department. No, sorry, this is fishery.
Fishery.
But matter.
Fisheries Development Corporation. But
Sorry,
it is shown as
Matter
fishery.
relating to AFDC matter, Assam Fishery Development Corporation matter, not Fishery Department matter. Here matter name of Fishery Department is shown.
so you're not brought the brief.
Well, I'm not the standing counsel of AFDC matter.
Okay, who's the standing counsel?
Please, Roma matter.
So what is to be done?
Copy of course.
But their name is not shown.
No, they are not ready because they have not seen in the cost list. What is the name? I mean, what is the thing? Authority?
AF.
AFDC.
Yes.
Assam Fisheries Development Corporation.
Yes, but it is shown as fishery department only.
Okay, we'll list again on Tuesday, next. Okay. As paid for, list the matter again on Tuesday. Dates 17 to 2026. Showing
Showing the name of the.
SC AFDC in the cost list instead of Fisheries
Fishery
Department.
department. Of life. 30.
Please, your lordship, my lord. There are so many orders, similar orders.
Item number 7, my lord, just at the big matter. 7, your lordship has passed an order just now. Similar order.
My lord. Yes, my lord, here is, the petitioner is devoter in 2005 brutal, 25 brutal, page 41.
25.
First time in 2025 brutalist.
Page 41.
My lord, page 41. Earlier, his name is coming up in the voter list in 1997. Sorry, 85 also. So in 79 also. 79 onwards he is voter. And
the voter since when?
my lord, the voter first time, my lord, in 97.
97.
Yes.
Page 41 is a voter list of 2025.
Yes, my lord, 25 voter list.
97 on what's matter? Till date matter.
Yes, 32 is annexure 6, lordship. That is the 1997 voter list of 38 Golpara West. Here he has been first marked.
D.
D.
Abdul Matlib.
Abdul Matlib.
This is the one.
Yes.
I see.
CL number 215. It's 38 Golpara West.
My lord,
LAC is what? What is the LAC?
5 voter list, page 41.
At that point of time, your lordship,
Abdul Matlib.
the LAC was 38 Golpara West. After delimitation, lordship, now the LAC has changed to Zolesur. 12 Zolesur. LAC.
Where do we get that?
In last page number 41, lordship.
41.
12 Joles Shore LSC from
2025. This is 2025. After delimitation, it has been changed.
no, earlier it was what was it? Earlier?
It was
38 number
Ramgurichar part 2 and LSC
38 Golpara West.
yes, 38 Golp.
38 Golpara West LSC, correct?
Yes, yes.
Okay. So we dispose it of accordingly in similar lines. Heard Mr. R. Sikdar, learned counsel for the petitioner, comma, Mr.
I will appear for respondent number 2 and 7, madam. J. Pine for respondent
J. Payang for respondent numbers
2 and 7, madam.
2 and 7, comma,
A. Ali for respondent number 3 and 5.
Mr. A.I. Ali for respondent numbers 3 and 5. Miss N. Prakasta.
N.B. Kayastha.
N.V. Kaista for respondent number 4. And Mr. S.R. Barua, respondent number 6. Stop having regard to the nature of grievance projected by the petitioner. The writ petition is taken up for disposal at this stage itself. Stop. It is the case of the petitioner that he has been marked as D voter.
Here the SP voter Golpara will verify. My lord.
In the voter list of 1997, without giving him any opportunity to demonstrate that he is a genuine citizen of India by producing relevant papers and documents. Stop. Therefore, by filing this writ petition, the petitioner prays for a direction to the respondent authorities concerned to remove the tag D from the voter list. The learned counsel for the respondents, on the other hand, submit that similar matters have been disposed of by this court by directing the superintendent of police border concerned to verify as to whether the person concerned had been referred to the foreigners tribunal for opinion, and if not, to do the same. Stop. Accordingly, stop. Therefore, the learned counsels for the respondents pray that the present matter may also be disposed of in similar lines. Next para, be it stated herein that whether the petitioner is a D voter or not is a fact which has to be determined by the appropriate forum. And to do the same, the foreigners tribunal has been established. Stop. Therefore, this court, in exercise of the writ jurisdiction, does not have the competence to decide questions in which evidence are required to be taken. To stop. Next para, in view of above, the writ petition is disposed of by directing the
Respondent
superintendent of police border
Golpara
Golpara bracket respondent number
7.
7 to verify as to whether the petitioner has already been referred to the concerned foreigners tribunal or not. Stop. If upon verification, it is found that the petitioner has not been referred, the respondent number 7 shall refer the case of the petitioner. What would be the LSC? To the
Concerned foreigner too.
concerned foreigners tribunal in respect of the
Golpara still. 13 dollars.
marking of D in the voter list of the petitioner. To stop. It may also be stated herein that earlier the petitioner fell under the 38 Golpara West LSE. But now, after what? Of the delimitation, the petitioner would fall under the jurisdiction of 12 Joleshwar LSE. Next para, the reference be made within a period of 2 months from the date of receipt of a certified copy of this order. and upon such reference being made, petitioner may participate in the proceedings and establish his case. So it is also provided herein that if the petition before the concerned foreigners tribunal, there would be no further requirement of making a second reference. But however, the petitioner shall be given a detailed information of the reference that has been made by communicating the same to him. With the above observation and direction, the petition stands disposed of.
My lord, may I pay for, my lord, one line that the petitioner may be given opportunity to produce all the voter list, my lord, 1966 onwards, my lord.
It is
So the inquiry was.
it is also provided herein that in
My lord, at this stage, probably there will be no inquiry, because already it is an inquiry is done. Now it has to be referred to the foreigners tribunal. So he will get enough opportunity in the tribunal to produce everything.
No, my lord. My lord, there will be a verification by the SP. During that verification.
If already.
Before referring, he is to verify, lordship has passed order, my lord. So in that verification, I may be given.
Verification whether my lord, verification to the extent whether the matter has been already forwarded to the foreigners tribunal or not. That must only. Because
everything, my lord.
once ERO, my lord, these are e-voter cases, my lord. Once ERO done, e-voter cases, once ERO verified, police has no authority to re-verify, my lord.
Mr. Siddhar knows that.
Yes.
I think you know it also.
Yes.
Court is also not having that power.
Yes, ma'am.
The police also doesn't have that
Yes,
power.
doesn't have
The tribunal, you are free to produce anything that you have in your power and possession before the tribunal. All right.
Supplementary list, item 31.
May it please your lordship. The matter relates to issuance of trade license to the petitioner, your lordship. Trade license to the petitioner to run and establish a private cattle market in his land, your lordship. The petitioner filed a representation before the respondent number 3 in this aspect, your lordship, which has not been disposed of till date, your lordship.
What did you file? Representation?
Representation, your lordship.
Page?
Turn to page 18, your lordship. Annex number 3.
Representation for what?
Page 18, your lordship. Annex number 3. It was on 26/9 of 2025, your lordship.
When did you file this?
26/9 of 2025.
From where did you get the date?
This is a page 18 of the writ petition.
Date is handwritten
Oh, date is.
on the top.
Top, your lordship.
When did you write? After filing while filing writ petition?
No, my lord, it was filed. It is sent by the registered postal,
Application is written by hand.
your lordship. Registered, it was sent on registered post, your lordship.
Cannot be read, your lordship. The dates and all. Your acknowledgement.
You can read this registered for receipt. Are you able to read this?
Your lordship.
You have also annexed it upside down.
Date to send browser as well.
What has it? Please,
There.
26 what? Month? What is a month
26.
of? Which month?
26th of which?
26 of September, your lordship.
Okay, so
Representation may be, direction may be for dispose of the representation, your lordship.
The lordship discretion.
you come here only for a direction for disposal of representation. What kind of case is this? What you're seeking for running a private cattle market? Who will give you the permission?
Your Lordship, response number 3 may be directed to.
BTC?
R3.
Response number 3, Your Lordship.
R3 is Secretary Market and Fair Department. BTC, Pokrachar.
What do you say, Ms. Bhuy?
Leave it to your Lordship's discretion.
This was the particular.
I don't think, I'll leave it to your Lordship's discretion. This kind of petition, whether your Lordship will entertain.
Direction will be given to for the dispose of the representation, Your Lordship.
Or would you like to get some instructions as to whether such kind of application has been received or not?
Yes, it's on a private land. They have to fulfill the criteria also, your Lordship, in order to, I may take instruction.
Get the status.
To your Lordship's discretion, if your Lordship directs. With a
Fine.
stipulated period, his representation be considered or may be considered. It may be rejected, may be allowed, man. It's up to the authorities concerned.
Okay, heard Miss
A Begum.
J. Begum.
A Begum.
A. Begum, learned counsel for the petitioner. Ms. B. Bhuya, learned senior counsel and standing counsel BTC for all the respondents. All respondents or Huh? For respondents 2 and 3?
Commissioner Secretary Welfare Plain Tribes.
And also Miss U. Das for respondent number 1. Of having considered the limited prayer made by the petitioner, the writ petition is taken up for disposal at this stage. Stop. It is the case of the petitioner that he has filed an application before the Secretary, Market and Fair
Department is.
Market and Fairs Department, BTC.
Market and Fairs Department, BTC, for issuance of a license to the petitioner for running a private cattle market on Schedule A of the land mentioned in the said representation. Top. The said representation was submitted to Speed Post
Speed Post.
on 26/9/2025, bracket annexure 3. But the same having not been considered, the petition is before this court. So the learned counsel submits that the limited prayer of the petitioner at this stage is for directing the respondent authority concerned to consider the petitioner's representation and dispose of the same in accordance with law. Next para, Ms. B. Bhuya, learned standing counsel, BTC, submits that court may consider and pass appropriate orders as it deems fit and proper. Next, considering the above, the writ petition is disposed of with the direction to the respondent authorities, more particularly respondent number 3. To consider and dispose of the representation submitted by the petitioner on 26/9/2025 in accordance with law, as expeditious as possible and preferably within a period of
6 weeks.
6
So
weeks.
May I make a prayer? She submitted representation on 26/9/2025, but the government has changed. New government has taken over in December, maybe in October, your Lordship. So, Lordship, I don't know whether it will be available or not. She may file a fresh representation before the authority is concerned. How about it? Government changes, BTC, no government anymore.
Or you file this writ petition.
Your Lordship.
Let us furnish this writ petition.
Will for a fresh notice, Your Lordship, fresh representation, Your Lordship, along with this order. Along with this order, Your Lordship.
You have come to court only just for that.
Your Lordship.
You could have very well filed a fresh representation without coming to the court. No, we'll say like this, what I say last.
Council has said in accordance with law,
From the date of receipt of a certified copy of this order, the petitioner shall also furnish a copy of the writ petition to respondent number 2, respondent number 3, along with the certified copy of this order for the needful. Okay. You give one copy of this writ petition also and with your certified copy of this order.
Okay, Your Lordship.
6 weeks, my lord, dispose.
Yes.
Yeah.
One more line, the order to be passed by the respondent number 3 shall be communicated to the petitioner.
Your Lordship.
Yeah.
32.
Well, may I please your lordship, my lord? Here, my lord, instant case what happened, my lord? 32, 33, 34 is the same, my lord. What in the instant case what happened, my lord? The petitioner was awarded, my lord, contract, my lord, for LPG bottling plant, my lord, for my lord, for construction of shed and etc., my lord. And petitioner
Construction of shed.
shed, my lord.
Shed.
Shed, my lord. For keeping the LPG, my lord. Petitioner has
Not for bottling, only for shed.
only shed, my lord.
I see.
For storage. For
Storage.
storage purpose, my lord, this has been, my lord, constructed. What happened, my lord, instant case, my lord? The petitioner has successfully completed the contract, my lord. And my lord, some additional work also given, my lord. That was also successfully completed, my lord, completed, my lord. And my lord, there is a clause of defect liability period, my lord. That defect liability period is over, my lord, in the instant case, my lord. When the defect liability period is over, my lord, in second case, my lord, even security money also, my lord, return back, my lord. Now what happened, my lord? At the time of, my lord, when our bill has been prepared, there is a joint verification from the, my lord, employer and employee, my lord. And after the joint verification bill has been prepared, and we paid the bill, my lord. Subsequent joint verification has been done, my lord, from the contract.
You paid the bill or you received the bill?
I received the bill, my lord.
Wow.
I received the bill, sorry. I received the bill. There is a joint verification from the, my lord, IOC and the petitioner, my lord. After joint verification, my lord, bill has been paid to the petitioners, my lord. That is not there. And defect liability period is also over.
What is the construction you have done? Anything?
That, my lord, construction, your lordship will find, my lord.
Where is the
Yes, my lord.
work order or the
Washroom and the other, etc. If your lordship go to the, my lord, I am first nutshell, my lord, I am giving the facts, my lord. The shed has been constructed.
No, I've understood. You have
Yes.
constructed a shed,
Yes.
everything over, defect
Yes.
liability period over.
Yes, my lord.
But now they are demanding some excess payment from you. They say that
Yes, my lord.
you have been given more money than what you deserve.
Yes.
So they said, give us back.
Yes, my lord.
Against that you have come?
Yes, my lord, but we are not paying any excess payment. My law is something, my submission is something different, my lord.
Okay, just show me the work order. Just
Yes, my
see the
lord.
work order.
Work order is, my lord, base.
How many work orders?
There are two work order. One is additional work order. Page 36, one. That contract for carrying out capital revenue of retail outlet, including consumer pump, depot, terminal, lube, LPG plant, aviation fueling station building, etc. under the Tinsukia Divisional Office of Indian Oil AOD State Office. That is the work.
Valued at 615,160.
Yes,
This
ma'am.
one, na? On the top.
Yes, my lord.
Okay.
And there are after my lord, one additional work order also given, my lord.
Page.
Annex 2, my lord.
Uh,
Service entry sheets 1574180. Page 39.
additional work order.
Yes, my lord. Number, your lordship, work order number, date also be mentioned, my lord. Work order number, date. My lord, from my lord, bottom 1, 2, 3, 4, 5, 5, my lord. It was issued on my lord 18/10/2022, my lord.
Mm.
Then, my lord, we also raised the bill, my lord.
Mm.
We completed the work. The one thing is important, my lord.
Mm.
They have issued show cause notice to the petitioner, my lord. Only show cause notice. My lord, on the show cause notice, everything your lordship will.
Have you
Get-
replied to the show cause?
Yes, my lord. I want to go to show cause because facts, every facts is available show cause on my reply, my lord.
Show cause is at page?
Page, my lord, 21/10/2025, my lord. Sorry, my lord. 51, my lord, 7/10/2025.
Mm.
May I read, my lord?
Yes.
This is referent to the work of construction cylinder repainting set LPG bottling plant Dimapur, awarded by to you, Indian Oil Corporation Limited, assigned to you. Purchasing document number so and so dated 18/10/2022. The work construction is taking yard at LPG bottling plant, Nagaland, assigned you to purchasing document number so and so 16/6/2022. Both PO was described, my lord. One is 979,
Just a
137.
minute, just a minute. This 18/10/22 is regarding that additional.
Yes, my lord.
It does not refer to the original one. 16/6/2022 was
Yes, my
there.
lord. Both are, my lord.
No, only one has been referred here. 18/10. So
The
there's
both PO has been mentioned, 28248-175, 270-96440.
purchasing document
Yes, my lord.
28248-175.
Yes, my lord.
That is this is the additional
Yes, my lord.
work order.
Yes, my lord.
So there is no problem with regard the original work order.
Yes, my lord. That is no problem, my lord.
Okay, only the second one.
Their allegation is that, my lord, I have executed some work, my lord, which has been assigned by the, my lord, IOC official, my lord, which is not included in the tender. Is correct? That is the direct, my lord said. I said they have stated to me, I executed the work, my lord. My humble submission is not that, my lord. They, your lordship, directly come to the, my lord, page 52. Have you also got it? Next page, my lord.
No, you come to page 51 only.
Yes.
You read from the second last paragraph.
Yes, I am reading a whole, my lord.
Okay.
However, during recent verification, inspection was executed under this, it has been observed that quantity bill is more than actually quantity exceeded for more the PO and extra additional item were executed which are not included in the PO. What I say, this has resulted in excess payment 2,92,923. The vendor bear a critical responsibility in ensuring accuracy, integrity of the final measurement sheet submitted billing purpose. As per standard practice, final measurement are recorded in the presence of both plan authorized personnel and the vendor representative. By participating in the process, vendor implicitly certified the quantity recorded are true and respective physical completed site. Any deviation, inflation, misrepresentation in this measurement, whether any omission action constitutes breach of contractual obligation. It is worth mentioning that you are fully accountable verifying the endorsing the correctness of the measurement sheet prior to bill submission. Any discrepancy discovered post-payment system may be constituted as evidence fraudulent intent, gross negligence. In respect of the aforementioned work, you have prepared an incorrect joint measurement sheet knowing fully well, my lord, it was done by joint verification, my lord, that it does not commensurate with physical work done. You had also assigned it did not bring to notice to the corporation when amount exceeded actual work done was paid to you. It can be inferred from the above. You deliberately prepare and sign incorrect measurement sheet with a dishonest intention for causing wrongful loss, financial loss to the corporation and wrongful gain to you. There is some stigmatic view made against the petitioner, man. This mention, my lord. It may be noted that corporation has also holiday listing guideline dated 19/1/2022. The relevant clauses policy are mentioned above. Herein under putting holiday 2.1 guideline khano.
What is that?
This is holiday guideline.
Holiday.
On the basis of which they are declaring me holiday, my lord. declared me, my lord, blacklisting, my lord, holiday, declared holiday.
So blacklisting is called holiday,
Yes, for 1 year.
holiday list.
It's a holiday list.
My lord.
You have any objection on going holiday?
Objection, my lord, because my right under my law, fundamental right has been violated. There's a violation of natural justice. Law
No.
said before that you have to give the personal hearing to the petitioner, my lord.
I'm saying on the lighter note,
Yes, my lord.
holiday
And
is good,
if it is arbitrary, my lord.
and especially if it's a paid holiday, it's much better again.
Yes, my lord.
Mhm.
After 3 years, defect liability period is over. 2(1)(a), my lord. Come, my lord.
Yes, 2(1)(a).
The purpose of holiday list is to be protect corporation from dealing undesirable. Reason for putting a party holiday list include: 1, they have used 2(1)(a), has indulged in malpractice such as bribery, corruption, fraud, preferences, bid, rigging, price rigging, injury, reputation, property, corporation acting disorderly, causing wrongful financial loss to the corporation or wrongful gain to the party. They have exercised this power. And what does law say? Your lordship, come to next page. So cost 3.1. Next page, man.
So they've given you show cause.
My lord, they have issued so cost. I'm reading, my lord. That is very important, my lord. Before placing the party holiday list, a opportunity of fair hearing, the party say give me show cause notice. The show cause notice should be issued before party on holiday list except clause 2.2. Except 2.2, they have to issue and they have to give fair hearing, my lord. What is the meaning of fair hearing, my lord? They have to give all the documents, all the material collected by them before me, so that, my lord, I can, my lord, effectively give the, my lord, my defense before the, my lord, authority. That was not done in the instant case, my lord. Purely, my lord, effective hearing should be given, my lord. And what they have done, my lord, they have prepared a report behind the back of the petitioner. On the basis of that, my lord, I was declared a holiday. I give reply everything, my lord.
Where is the declaration of holiday?
My lord, that is, my lord, 2.1(a). That I'm read, my lord.
No, in your writ petition, where have you been declared a
My
part
lord,
of the holiday list?
holiday list was not mentioned, only so cause mentioned. Subsequently, my lord, they have, my lord, declared holiday 56, my lord.
They have declared.
Yes, but before that, my lord, your lordship kindly go for my reply, my lord, of that so cause notice, because it is important, my lord. I am asking something, my lord. Page 54, my lord.
No, we'll come to that, but tell me, have you been declared to be a part of the holiday list?
Yes, my lord. I was declared in the holiday list, my lord.
Where is that?
56, my lord.
Oh, you have been placed in the holiday list now.
Yes, my lord. Without giving me a fair hearing, without producing the document. In fact, in my reply, I am asking all these things, my lord. In fact, I prayed for joint verification also. Nothing done, my lord. Without hearing the petitioner, this impugned order has been passed, my lord.
Okay, so that's your case.
Yes, my lord. Then, my lord, page 53, my reply. With due submission, I acknowledge received so cause notice dated bearing reference so and so, express my certified deep concern over receiving communication. All the reference duly completed 3 years. The concern was expired on 9/10/2023. The defect liability also included in due course. Defect liability period also completed. Throughout the entire intervening period, there has been no corresponding observation, intimation suggesting any discrepancy, irregularity execution. No communication, whether by letter, email, or phone, was ever made prior to the notice. We take pride in the IOC corporation as a trusted vendor for over 2 decades executing SL, utmost diligence. That is not important, my lord. Then my next paragraph, 54, second paragraph. All measurements were taken by the site engineer themselves, and no separate measurement book was ever prepared and submitted by us independently. There is invoices raised by us, based sole finalized measurement duly approved authorized IOCL. Then, your lordship, I have mentioned something. Your lordship, kindly come to the prayer portion. Just before my lord, second paragraph, from bottom, my lord, second paragraph. In the interest of natural justice or for fair transfer, we formally request you IOCL can provide the following detail earliest. Specific detail of alleged discrepancy in the measurement sheet, copies of relevant document, including comparative measurement record, the date, time, personnel present during subsequent if conducted. Before that, my lord, we also prayed for joint measurement. That was not done in the instant case, my lord. And subsequently, I declared in the holiday list, my lord.
Okay, now you have given me this paper.
My lord?
You have given me this paper.
Yes, my lord.
Out here, there is a provision at clause 6,
Yes, my lord.
appeal and review of holiday.
Yes, my lord.
Have you exhausted that remedy?
Coming, my lord. A general condition of contract, my lord.
See, you are saying that as per the show cause notice, under this provision,
Yes, my lord.
holiday listing guidelines and IOS, holiday listing guidelines.
Yes, my lord. This is the guideline, my lord.
Guidelines, show cause is there.
Yes, my lord.
Then you are saying that show cause means they have to give me the meaningful documents
Yes,
so
my
that
lord.
I can reply,
Yes, my lord.
and which has not been done.
Those are not done, my lord.
And now they have blacklisted you.
Yes, my lord.
Now, this same guidelines also provides for appeal and review.
Yes, my lord. I filed
So you file appeal.
appeal file, my lord. Nothing has been done.
Where's the appeal?
And my lord, my one is that, my lord, I have filed a, my lord, the appeal, my lord, before the authority, my lord. I'm coming on of that, my lord. When my fundamental right has been violated, because appeal defect liability period is over, there is a procedure established on odiotum partem. You have to give this thing, my lord.
Okay.
That was violated. That you have to give fair hearing. You have to give, my lord, that, my lord, document. Without going the document, what is available in the record, how can I rebut my case, my lord?
All right.
That is why. And that
All
is why my right under Article 14 has been violated, my lord. And there is a one judgment I have annexed, my lord.
You have not filed appeal.
My lord, I am not filed. I am authority. I am again right a representation, my lord.
You have filed or not?
That does, my lord, in page 59, Chief General Manager, my lord.
What is this? Reconsidering.
My lord, without going to the document, how can I file an appeal, my lord?
No,
I
that
want- Yes,
that
ma'am.
I've understood.
Yes, my lord.
Only question is whether you filed appeal or review or revision like that.
No, my lord.
You have not filed.
Representation, again, file a representation.
You have only filed this representation
Yes,
for
ma'am.
reconsidering.
Yes,
That
ma'am.
much only.
Because
Okay.
without
Now-
document, I cannot, my lord, rebut my
Okay.
case. I am on judgment, my lord. I have annexed, my lord.
Apart from putting you in the holiday list,
Yes, my lord.
what about the money?
They have tried to, they are asking to realize the money that not 2,09,000, my lord.
Have they
90%.
recovered?
Yes, my lord. In that order, it should mention, my lord.
Have they recovered? Have you paid?
No, my lord.
Okay.
I one husband of the, my lord, Apex Code, my lord. I give 1971 SS 70, my lord. Photocopy diya, sir.
Now,
Yes, my lord.
we'll come to that. I think it's attached to your paper you've given me.
Yes, my lord.
But where in the holiday list have you been asked to pay the month,
The holiday list.
to repay the money?
Pass this order on, my lord, 27.
Okay. Consequently, you are hereby instructed to refund and deposit.
Yes, my
Okay.
lord. That is,
That you have not refunded?
I am not refunded.
Okay. This is dated
This is dated
January
1 2020.
22/1.
Yes, my lord.
And what is the judgment?
Judgment, my lord, I am given, my lord. Your lordship kindly come to the 1975 1 SS 70.
Measures erosion equipment and chemicals.
Yes, my lord.
Okay. Which paragraph?
Yes, my lord.
Paragraph?
20. Blacklisting has effect preventing a person from privilege and advantage of entering into lawsuit relations with the government purpose. Okay, this package disability has created by the order of blacklisting indicated there. Para 21. Authority to have objective set is a fundamental fair play required that person should consent given an opportunity to represent his case before his blacklisting, my lord. I was not given any opportunity. I asked the document. Without document, my lord, how can I rebut case? And word has been, that is why I want to show paragraph 3. You have to give hearing. The word has been used hearing. Before hearing, you have to give all the document. Otherwise, my right under my right under, my lord, 14 has been violated, my lord. That is my submission before your lordship, my lord. Let them show that we have given all the documents.
So we'll examine. Let's see.
Yes, my lord.
At this stage, what can be done? We issue notice. Apart from that. Anything to submit at this stage?
My lord.
Heard, Mr.
So, my lord, I have, there may not be any stay granted, my lord, today, as per my instruction.
Don't recover. That's all.
The recovery has been done. The recovery, there's an application called SAP, my lord.
there's a recovery which has been posted. Now subsequently, my lord, that adjustment will be done on subsequent payments. My instructions are this, my lord. The matter has come up.
Still some amount is pending from to be given to him.
The recovery has been posted in the application. That's what I've been told, and the recovery has been made. That is what my instructions are, my lord.
No, how do you recover? There's a
What
thing.
happens is that there's a PAD balance, which is called the product allocation balance, my lord.
Uh-huh.
There, all the contractors and all the vendors of the IOCL, they have certain amount kept with the IOCL as a security for anything that might happen in the future, but it is from that amount that the recovery has been made. That is what has been intimated to me, my lord. But if your lordship directs us not to, because what has happened, my lord, subject to, if your lordship permitting me to
No, if not already done,
if not already done,
that will be there.
Similarly, matter has been.
yes, there is a reason why this.
That the order has been published. My humble submission is something different, my lord. My submission is
My lord,
something
what has
different.
happened? My lord, what has happened? Today, there's a matter which was item number 4 in your lordship's list. And there's a affidavit which I was directed to file, my lord, which the matter has been filed. In that aspect, my lord, there are 2 prayers that the petitioner has sought in item number 4. Similar matter. That there should be no recovery and there should be no putting of holiday list of the contractor in the petitioner in item number 4. Now, the recovery part has been stayed by this honorable court on 4/2/2026 because we did not have the instructions on that day. Now, my lord, we have instructions. In fact, we have made a submission in the affidavit that there were a couple of IOCL officials who, in collusion with the petitioners, with utmost respect, I'm submitting this, my lord, had indicated works done which were not reflected on-site.
Anyway, these are the arguments to
Those
be.
admitted now.
These are the issues to be considered at the
True,
time of
True, ma'am.
argument. At this stage, we'll issue notice.
No, ma'am.
What I'm saying is that both sides, even for the counsel for the petitioner, please consider this thing, that they say that there's a system wherein if they put you on that system, recovery happens. And according to his instruction, recovery has happened.
Yes.
You say that recovery has not happened. So to be fair and square, that no injustice is caused to anybody, I say that there shall be no recovery. Okay, fine.
That it is correct, Maria. My humble submission is something different, man. My humble submission different. Let him say he has all the instruction. Let him say that all the document on the basis of which I was declared holiday, whether it was served to the petitioner, it was not served to the petitioner. Let me record. Because if that is so, then immediately that is so, my fundamental right has been violated.
That is the point.
Yeah, and if the fundamental right has been, I am, natural justice is also fundamental right. Arbitrated in Article 14.
I agreed,
Yes,
completely agreed.
And he say all instruction is available. Let him say all.
See, agreed with you, judgment is here, everything is here, but at this stage, we cannot go to that extent of considering everything and disposing it out.
He say want to say there is a security amount. He want to recover it from them. How can can be done, my lord?
I can, because I've shown admitted.
This is arbitrary exercise of power.
Natural justice is not a loose cannon, my lord.
Okay.
My lord.
Heart, Mr.
And one case, second case, security deposit has been, my lord, returned back, my lord. Similar matter, my lord. 33 security money has been returned back, my lord.
We'll come to that
Yes, my
step by step. You are Mr. NNB Chaudhary, na?
Yes, my lord.
Heard Mr. NNB Chaudhary, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the show cause notice dated 7/10/2025, bracket annexure Roman 6, and the communication dated 22/1/2026, bracket annexure Roman 8, by which, upon serving a show cause to the petitioner has been enlisted in the holiday list. So in other words, the petitioner has been blacklisted by the respondent,
234 man. IOC.
Indian Oil Corporation Limited.
Hello.
Without giving the petitioner adequate opportunity of hearing, and also all the relevant materials demanded by the petitioner prior to being blacklisted in the said manner. The learned counsel submits that the same is only not only in violation of the standing guidelines of the IOC Limited, insofar as holiday listing is concerned, but also violates the fundamental rights of the petitioner, including Article 14 and Article 19(1)(g) of the Constitution. Stop. He thus submits that the show cause notice and the impugned communication for blacklisting should be set aside. You cancel that line again. He therefore submits, not required at this stage. Instead, you write, the learned counsel submits that on account of certain work which was given to the petitioner, the respondent, Indian Oil Corporation, has alleged that there has been an excess payment of rupees 292,923 to the petitioner, and which, according to them, was a result of the incorrect measurement sheet presented by the petitioner with a dishonest intent to cause wrongful financial loss to the corporation. Stop. Unless such type of allegation is supported by relevant materials, which the petitioner was clearly denied of, the impugned action of the respondent authority concerned is liable to be interfered with by this court, as the same is not sustainable. Next para, in view of above, issue notice returnable by, when do you want it?
Other matter is fixed on 18.
Item number 4, my lord, was fixed on 18. But in that matter, I filed my affidavit. My lord. When the matter comes up on 18th, I can pray before this honorable court that the matter be taken up with the subsequent matters which your lordship will place, because we need some time to file 3 affidavits, my lord. The instructions will have to be taken from the IOC.
3 weeks?
My lord.
3 weeks? 3 weeks?
3 weeks, my lord, on a fixed date, my lord.
I was in holiday list. Now today I cannot participate in any tender process, my lord.
Of the IOCL, there is no tender, my lord.
IOCL, I'm coming with IOCL. IOCL, my lord, if your lordship give 3 weeks time, I cannot participate in any tender process. Other matter is on 18, my lord. Let them take the instruction, my lord, on that day, whether all the document has been given or not, my lord. Because I cannot participate in the tender. Otherwise, you also stay the impugned order, my lord. If you also stay the impugned order, then I can participate in the tender process, my lord. That is my humble submission before your lordship. Otherwise, this way, my lord, 1 year will be over, my lord. This matter will be in fact. Absolutely, no, lord. My lord, that is why I am submitting, my lord.
Take a shorter date, that's all.
18 other matter has been fixed, my lord.
18 is next week only.
18 is next week, my lord.
That
By
will-
then, the most we can have is oral instructions, my lord. The most, my lord. So, my lord.
Affidavit will be same, my lord. Same, my lord.
But the paragraph.
Because I am holiday list, my lord. Tomorrow I cannot participate in any tender process. Despite of that, my
But what to do? Anyway, we'll have to examine your case now. We cannot straight away like that jump
Will be.
to the conclusion.
Document
Returnable by 3 weeks. Mr.
M. Sharma.
M. Sharma, Learned Standing Counsel, IOC, accepts notice on behalf of
2, 3, and
respondent numbers 2, 3, and
4, 1.
4. Who is the one? Miss A. Sharma, Learned Counsel, accepts notice on behalf of Mr. P. Chakrabarty, Learned CGC, who represents respondent number 1. Notice is therefore complete. Having regard to the nature of the case projected by the petitioner, it is expected that the respondents shall file their response to the writ petition expeditiously or not before the next date fixed, so that the matter can be finally decided. Stop. It is also provided herein that the amount of excess payment that has been demanded back from the petitioner should not be recovered by the respondent authorities if the same has not been recovered already as on today.
Well, can we give?
My lord, to expedite, my lord, if you are permitted to file one affidavit for all the 3 matters, because the gist is same, then the issue can be quicker, my lord. So, because to assist my senior friend here. Because he wants to close the shorter date.
But that's entirely up to you,
My lord.
Well, Lord,
because the other cases are not yet before this court, only one case now.
No, my lord, other, next 33, 34 same.
I know, but we are yet to see that file.
Yes, sir, yes, ma'am, yes, ma'am.
So how do I say here that you
Yes,
file affidavit for that case also?
Yes, ma'am. Correct, ma'am.
List again on
33. Date, my lord, 18 of the.
Any date after 18th and before 25th, my lord, I'll try my
Oh,
best to.
That fair service.
What?
Fair service.
One more week I'm seeking, my
Yes,
lord,
ma'am, yes.
just to file an affidavit at least
23.
24.
Make it 24, Tuesday.
Yes.
Ah. Same, my lord. May I read, my lord? Amount is something different, my lord.
Yes, give me the page number of the impugned. Show cause notice is at page 47.
Yes, my lord. Suppose.
47. Then the
The page 50, my lord.
page 50,
Yes,
Page 50, my lord.
yes, yes.
the holiday list.
The holiday listing.
Yes, my lord.
My lord.
And the amount due is
Amount is, my lord, here, my lord, some, my lord, bigger amount, my lord. Amount, my lord, is 7,18,411.91.
okay,
In synopsis, I have it.
all right. And the position of the respondents is the same, is it?
Yes, my lord, yes, same.
Everything is same.
Yes, my lord.
My lord, the paginations are not correct. In fact, the holiday listing starts at page 47. The index indicates it to be page 50, but it actually starts at page 47.
47 is the show cause notice.
No, my lord.
My copy
Yes,
says
yes,
that
my lord, my lord.
annexure Roman 4,
Yes, my lord.
page 47
It's actually.
is the show cause notice. Mr. Chaudhary, you have supplied different copies to the council and to the court, and your copy is also different.
He said, my lord, his copy is not so legible. No, no, let me.
Okay, similar order. What you'll note down is show cause notice is dated 7/10/25. And number 2 is the impugned letter communication is 22/1/2026. This is regarding the blacklisting. Then the amount of recovery sought to be recovered is rupees 718,411.91,
Yes, my lord.
remaining same.
Next is same, my lord. Amount is different, my lord. Yeah,
Okay.
amount is, my lord.
Let us go to the show cause first.
Yes, my lord. So, cause your lordship will find, my lord, 35, my, sorry, page 45.
45, right. Then, blacklisting is page 48. Then amount is,
Amount is, my lord, 23,05,097.85. Now 23,05,097 rupees 85 paisa.
lucky, right? Chauffeur's notice dated 7/10/2025. Bracket annexure 5. Number 2 is the impugn letter dated 22/1/2026. Annexure Roman 7. And the amount of to be recovered is rupees 23,05,097.85. Same order, huh? Next para, it is
Same table.
submitted by the Learned Standing Council, IOC, that considering the urgency expressed by the Learned Council for the petitioner, the respondent IOC may be permitted to file one affidavit. File an affidavit so that the same covers the other 3 matters
3 matters, man.
which has been filed by the petitioner. That is WPC numbers 800 of 2026, 804 of 2026, and the other one,
805, man.
805. No.
800, 804, 806. This is 806, man.
No, morning item, there was the item. What was that item?
This item is 806, 2026, Rhino Enterprise.
Item 4.
Item number
No.
4 of the list.
Today there was one matter in the morning. Which was that?
A BK construction, man, item number 4, man.
But the council is different, isn't
The
it?
council is different, man.
What's the taxes?
The facts are similar. There were 4 contractors who had come under the holiday listing pursuant to the same excess work, my lord. BK Construction was one of the contractors, and 32, 33, and 34 are the other 3 contractors.
Okay, let it remain as it is then.
Yes, ma'am.
Then you, right? Apart from the instant case, that much. Considering the prayer, it is up to the respondent IOC to file a consolidated prayer. Keep side by side.
I'm grateful, ma'am.
My lord, pursuant to an NIT, my lord, dated 23 July 2025, my lord. The petitioner participated in a, my lord, competitive bid process, my lord, and letter of acceptance was issued.
NIT, where's the NIT?
That is, my lord, NXR 2, page 25.
Tender for what?
Construction of a hall, my lord.
Paul.
TL number 12, my lord, page 26.
Serial number 12. Community hall.
Community hall, my lord. Yes, my lord.
Hmm.
And being selected, my lord, letter of acceptance was issued. That is at page 28, my lord.
Yes.
And thereafter, my lord, notice to proceed with the work has been issued.
Okay.
That is annexure 4, page 29, my lord.
Hmm.
And the contract agreement was also executed on 26 August 2025, my lord. That is annexure 6, my lord.
Hmm.
And thereafter, my lord, the petitioner started execution of the work
Hmm.
after handing over the site, my lord. And he has completed more than 30% of the work, my lord. Suddenly, my lord, the authority has issued the cancellation letter, my lord. That is annexure 7, page 89, my lord.
May I read, my lord? This is the impugned, my lord, letter, my lord.
The reasons have been cited, your lordship.
New government,
Lordship?
new government.
Yes, BTC, my.
Is it because of new government?
No, no. It's reasons have been cited, my lord. He has failed to rectify the deviations, the deviation of work, my lord.
Yes, what does it say? Please read the cancellation.
With reference to the subject cited above, I say so and so, exercising the power conferred upon hereby terminate the contract agreement number so and so, dated 26/8/2025, with effect from the date issuing this letter under below mentioned circumstances. Whereas you have failed to rectify the deviations as per approved drawing and technical sanction estimate even after repeated instruction from this end. Whereas due to inferior quality of work, which is violation of the tender agreement clause. Whereas you have failed to achieve the milestone as per contract agreement clause mentioned in the page 38 of the contract data of the agreement. This notice has been issued under the hand and seal so and so. Here, my lord, prior to issuing this cancellation letter, my lord, no notice was issued to the petitioner, my lord, stating any deviation or alleging any deviation or using inferiority quality of, my lord, materials. So
What is-
you may kindly see,
You see the reference in the letter,
my lord,
in the impugned letter.
my lord,
3 letters have been mentioned here.
my lord.
26/8/25, 6/11/25, and 22/12/25. What are these letters?
This we have not received, my lord. I have not received any letter, my lord, and it is my special contention, my lord.
But
This
why
is
should
a-
they refer these letters then if they are not given to you?
At the face of it, my lord. This
But I have not received any letter, my lord. That is my instruction, my lord.
Okay.
And
How much work you have completed? 30%,
more than 30%, around 40%, my lord.
around 40%. As on
As on, my lord,
date of this note,
December, my lord. Big,
as on the date of the issuance of this impugned
my
letter,
lord,
40%.
my lord.
Okay. And time completion, timeline?
Timeline 6 months, my lord, and due to the model code of conduct, my lord, the site was handed over in the month of October, my lord. And I have to complete the work, my lord, within, my lord, February,
6 months.
6 months, my lord.
The contract agreement was signed on 6th August.
No, my lord, 26/8/2025, my lord, agreement was executed. And thereafter, my lord, within 7 days, the site was required to be handed over. But, my lord, on 28th August, my lord, model code of conduct was in force, my lord. And, my lord, result was declared of election, my lord, on 24, my lord, September. So, my lord, only thereafter, in the first week of, my lord, October, the site was handed over to the petitioner, my lord.
21st of October.
My lord.
Have you stated that somewhere?
My lord, in the month of October, my lord, first week of October, my lord.
Where have you stated
That was
that?
not specific, my lord. I have stated specifically, my lord. Paragraph 9, my lord. Page 9, paragraph 9.
October, it was handed over. He's paid.
My lord. My lord.
Month of October.
Yes.
My lord.
So what can be done at this stage?
Shiva, I'll take instruction from the authorities concerned. At the face of it, the impugned order is backed by reasons, your lordship. Why his order, lordship, NIT was terminated, lordship. Work order was terminated due to inferior quality of work, which is the violation of tender agreement, my lord. Then your lordship, rectify the deviations as per the approved drawings and technical sanction estimate even after repeated instruction from the end. And there's no illegality has been committed. The authorities have opted for e-tendering, and I have taken instruction from a learned friend from PWD department, B. Gogoi. He has throughout the state of Assam, e-tendering processes, lordship, they have taken up, lordship, throughout the state of Assam. So why not in BTC, my lord? Because lordship will find in other matters also they don't opt for e-tendering as per law, my lord. And at the face of it, even if he has completed, that is inferior quality of work, your lordship. There was deviation. So he is not entitled to,
But my
lordship,
lord, I have not received any notice.
at the
prior to
cost
the
of public
termination of the matter.
exchequer. At the cost of public exchequer, your lordship.
When can you get the instructions?
At this
Maybe
10
to-
days time be granted,
My lord,
shall the
but,
instruction.
NIT has already been issued, my lord, and NIT is going to, closing date
Let
is
him
my lord.
participate, let him participate.
Close, but it will be my lord stigma on my part for cancellation of the work due to inferiority.
Yeah, so it
Since
should
there
be
are,
listed
there are
on
my lord,
this
Where is the NIT?
my lord, that is
Next
NXR
page,
8, my
90.
lord, page 90, my lord.
Where is the date?
My lord,
6 February.
below my lord, critical dates, my lord. 20 February is the, my lord, last date of submission, and 21 February is the opening date, my lord.
Lordship, one more thing. Against the impugn order, here, the three letters have been referred to, your lordship. You can kindly find, it's there, page 89. But my learned friend, in spite of receiving this notice, he's sleeping over, your lordship, no representation, nothing as such.
My lord, I
He
have,
should have asked the authorities concerned, what are these letters? I have not received it, nothing as such, my lord.
I have
No
received the letter, my lord.
representation.
I have received the letter only on 30 January.
Which
That-
letter?
That is
17
cancellation letter, my lord.
letter.
17/1/2028, my
No
lord.
representation,
Cancellation.
nothing.
And thereafter,
Today
my
we
lord,
are on 13th of February. He received it at 30th.
and my lord,
13 days have gone by.
on
13,
2nd day
14
of
days have
February,
gone
my
by.
lord, fresh NIT has been issued in respect of that, my lord.
On which date?
My lord,
Which date? 2nd February. NIT issued
NIT,
on
my lord, 2nd February, my lord, published date, below, my lord, published date is critical dates, my lord.
then
Page 90, my lord.
bid opening is 21st
In
February.
the opening is 21st January. February,
Published
my
it to 2nd of February.
Then what else? What is the other stage?
My lord, I have received the letter of cancellation on 30 January, and thereafter on 2nd February itself, my lord, this NIT has been issued in respect of
In
the
this case,
same
if you
note.
make
my lord.
out a case, yes, lordship pleaded as such.
That record
Let
will
me take
reveal, my lord,
instruction
there-
from the authorities concerned, my lord. At a face of it, your lordship, his a work order should be cancelled. Lordship, he has failed to, lordship, fulfill the criteria as envisaged in the NIT, my lord.
And my
The
specific instruction is that, my lord, they have not received any letter alleging, my lord, any defects. of-
okay, you have said that. I've heard. You don't have to repeat that again.
Lordship, I think instruction from
See,
authorities concerned.
see, the critical date says that this is the fresh NIT, 2nd
Lord.
February. Then bid opening date is 21st February. Today we are on 13th.
13.
Attend, my-
So have you participated? You have not participated.
I have not participated.
You
my lord.
participate. Is it
But-
late now?
I don't
Are you
think
too
so.
late?
Yes.
Can you still participate?
I have obtained instruction, my lord, but my lord, I have already completed more than 30% work.
30%
That is also
inferior
required to
quality
consider,
work, my lord.
See, forget about your problem at the moment.
My lord,
Can you still participate?
my lord, I have to obtain instruction, my lord, in this.
No, from this bid document, does it say any last date?
Last date
This
is
is
still there, my
25.
lord.
Huh?
20 February is the last date, my lord.
28th. Bid opening, then document the sale and notice, 28th February.
Still there, my lord.
Where is that?
In the right column, my lord.
And
90, my
clarification,
lord.
lordship,
Hmm?
yes, page 90.
Page 90, my lord.
90, which part?
Last but
Last,
one
my lord. Bid
paragraph.
submission start date 2nd February and bid submission end date 20th February.
End, okay.
My lord.
So, see, you can do one thing, you can participate without any prejudice to your right to pursue this writ petition. We'll list this matter again before the opening date. You get your instructions by then.
But, my lord, if it is finalized in the meantime, my lord. If
How
it
can
is
the audit
finalized in the
finalize
meantime,
before
I may not
21st?
be successful bidder, my lord. If it is, my lord, finalized in the meantime, then, my lord, my repetition will be, my lord, infractions.
That is why,
Because third party right will, my lord,
no,
will be
Mr.
created. my lord.
Counsel, you have not heard me what I'm telling you. First of all, the new bid is floated on 2nd February. The last date is 20th of February.
My lord.
Today we are only on 13th February. So today we'll issue notice and make and list again before 20th.
My lord, my
I
lord,
mean, before 21st, before the opening date.
my lord,
Meantime, you participate.
my lord,
Let her get the instructions.
my lord.
Okay. And we will see whether you have a case or not.
My lord.
And you also say that you have not received any of these 1, 2, 3 letters.
That is my specific.
So let's see, let them get instructions. They might have taken acknowledgement from you also. We don't know. Heard Mr.
UK does.
UK Das, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for setting aside the cancellation of the work allotted to the petitioner by letter dated 17/1/2026, bracket annexure 7. Stop. The learned counsel submits that after following due process, the petitioner was allotted the construction work for constructing community hall at Dakshin Bijni Degree College, Ananda Bazar, Baksha. What is this TN 1812 and all that? TN 1812, like that. Some code word. Capital TN dash 18 dash 12.
TN, yes.
Stop. Although the contract agreement for a contract amount of 94 rupees 94 99,870.37 was signed between the parties on 26/8/2025, comma, the petitioner could only start the work in the month of October 2025. That was the reason was? What was the reason?
My lord,
The reason for starting the work late?
my lord, model code of conduct was.
Okay, in view of the
PTC election.
in view of the enforcement of the model code of conduct at the relevant time. Stop. According to the petitioner, he has completed about 40% of the work allotted to him as on the date of issuance of the impugned cancellation of the work on 17/1/2026. And the petitioner, without being given any opportunity to show cause, in any manner, the respondent authority concerned has issued the cancellation of the work arbitrarily. To stop now, the respondent authorities have floated a fresh tender for completion of the remaining work. Through e-tender on 2/2/2026, and the last date for bid submission has been stipulated as 20/2/2016. To stop, the bid is of 2026, I'm sorry, 20/2/2026. Stop. The date for opening of the bid has also been notified as 21/2/2026. Stop. The learned counsel submits that unless the fresh tender floated by the respondents is state the petitioner is bound to suffer irreparable loss and hardship besides being blacklisted. To stop, the Learned Counsel also submits that the communications mentioned in the letter dated in the impugned letter dated 17/1/2026 has never been received by the petitioner. And therefore, the impugned action of the respondents is highly illegal and arbitrary. Next para, considering the above projection, let notice be issued, returnable by, when should we fix it?
On 19th of 20, my lord.
Ms. Bhuya,
Lordship,
we'll fix it for next Friday,
yes, my lord.
returnable by 20,
28th.
2/20.
Then
26.
not issue notice in this matter because it will come up in motion then.
Otherwise, my lord, it will go for admission in my lord.
Notice to put it will come up for admission, my lord. So since there is urgency,
Okay, considering the above projection, Ms. B. Bhuyan, Learned Standing Counsel, BTC, shall obtain instructions with regard to the allegation made by the petitioner and make a submission on the next date. Stop, it is also observed herein that petitioner would be at liberty to participate in the fresh tender process, he so advised, which however will be without prejudice to his right to press the cause of action projected by him in the instant writ petition. An extra copy of the writ petition be furnished to Ms. B. Bhuya to obtain necessary instructions in this regard. Or should we call for the records? Can you produce the records?
That may be my
Get the records.
lord.
after obtain instruction, short instruction, if not satisfied, then liberty is given to him, my lord. On the next date, if instruction is not sufficient, then lordship.
No, you get the records of Ms. B. Bhuyan, Learned Standing Counsel, BTC, shall produce the records pertaining to the decision for cancellation of the work allotted to the petitioner by the impugned communication dated 17/1/2026 on the next date. Produce. We'll see.
On 20th, my lord.
20.
Permission item 14.
My lord, in this case, the last occasion, since my lord, the notice on the respondent number 2 and 3, my lord, was very recently served, my lord. It was found for the my lord, postal tracking that was served. The court wanted that their presence may be necessary because it is there on their instance, my lord, we have taken the action, EPF authority, and any order passed may cause prejudice to them. Therefore, the court wanted them to appear. Some time was granted. Therefore, your lordship may either my lord fix the matter for hearing or may wait for some time, my lord, because it's only very recently notice was served on them. They may come. So either my lord, it may fix for in the month of March, and if they do not come on that date, my lord, lordship may wait.
It is right, parties are represented by the respective counsels, except for respondent number 2 and 3. Stop, on the last court date, notice was accepted to be complete on respondent numbers 2 and 3 in view of the Lavazima Court's order dated 19/1/2026. And matter was adjourned to enable the respondents numbers 2 and 3 to appear. Stop, however, it is seen that respondent numbers 2 and 3 have not appeared till date. Considering the same, let the matter be listed in the month of March. Will you want a date?
No, my lord, any date convenient, your lordship.
Be listed in the month of March on a date to be fixed by the registry. It is also observed that if the respondent numbers 2 and 3 do not appear or are represented by or remains unrepresented by the next court date, court may consider proceeding with the matter
Lordship.
on the basis of materials available in the court. Yes.
15.
Worship, the counsel for the application has left the court, my lord.
Oh,
Counsel for the application.
APDCL.
APDCL, my lord.
Who is the counsel?
B. Chaudhary, my lord.
B. Chaudhary.
Some emergency, he has to.
You must have emergency.
Things are
I have
complete.
come from Calcutta, so can I give a small brief and then your lordship may fix another date?
Although the pleadings are complete, my lord, any day.
Readings are complete, only hearing is required.
Correct. But then even if you submit in the end of the day, again, we give a date. What is the point?
My lord, your lordship may take a call.
When can you come? When can you come again?
Next week.
Since you're outstation.
17th or 26th in this month, if possible, as per your lordship.
Or else March.
Why March? This will not take much time. If it is fixed for hearing, we can finish, I think.
20.
20? No, 26. I have 26 and 17, it will be best check. Or otherwise, March. March.
26.
What is his name? Mr.
B.
Counsel.
Chaudhary, my lord.
Please write. Mr. B. Chaudhary, Learned Standing Counsel, APDCL.
26.
Having some personal difficulties, had left the court early today. And therefore, an adjournment prayer has been made on his behalf. Mr.
A.K. Srivastava.
A.K. Srivastava,
Yes.
Learned Counsel, appears for the petitioner and submits that he has come from outstation and prays that a convenient date may be fixed. Since the pleading, convenient date may be fixed for admission hearing, since the pleadings are complete.
Yes.
Next para, in view of above and as agreed to by the parties, let the matter be listed on so and so for admission hearing. You consult your
Yes, yes.
thing and give a date, we'll fix it.
3 dates you can take. 17, 26, this one, 26th of March. 26th of, yes. So he's agreed. to
You're
26th
agreeable
February.
on?
26 February.
Okay, 26th February.
Great.
16.
Yes.
Our senior counsel is having some eyesight problem. That is why the matter may kindly be
Who? Mr.
RC Bhattacharya.
Okay, Mr. Dr. R.C. Borpotro Gahan, Learned Senior Counsel, appearing for the petitioner. He said to have some personal problem.
Matter may
Conduct
kindly be
the-
listed after 25th of the instant.
Case today on a prayer made on his behalf and objected to by the other side. Matter be posted, any date,
After
March.
25th.
in the month of March.
after
They'll give a date, registry will give a date, okay? I'm not
After-
giving a date. But it'll be in the month of March. We listed in the month of March for admission hearing in the month of March on a date to be fixed by the registry.
If
17.
May I please, regarding my non-payment of contractual bill, my lord. As per my information, my lord, the similar matter has been disposed of where, my lord, the received challan has been disputed by the respondent authority, my lord.
So basically, we're disputing the amount.
Yes, my lord, that was in the coordinate base already disposed of the similar matter by referring, my lord, liberty has been given to approach before the civil court because the rate court cannot decide the, my lord, the original of the receipts and all, my lord. The same order may be passed. Paragraph 13, my lord, I have just given the order, my lord.
How much are you claiming?
Well, there are 3 repetition, 23,73,752 amount.
How many work orders are there? 1, 2,
There-
3, 4, 5,
There
6,
are,
7, 8.
yes, my lord. The
8 work orders.
Yes, my lord. Page 32 is the representation, my lord.
8 work orders, and which a total amount is 23 lakhs.
Yes, my lord, total.
That is the amount. And what is the alternative for you?
Approach the civil court.
To the civil court, my lord, since the challan, we have admitted, we have said that we have submitted the challan, my lord. And the
By filing
response
what? Money suit?
for, yes, my lord, civil suit.
What will you file? Civil suit, money suit?
Civil. Because the authenticity of the documents, my lord, report cannot decide. That's why, my lord.
I
the other-
understand. But do you also know that to approach a civil court, can you go anytime you want?
Limitation.
You're the circumscribed by limitation.
Yes, my lord.
Section 5 will not be there.
Yes,
But then, what about what is that section which says that approaching the wrong forum? Will that be available to you?
my lord. Sorry, my lord.
Time spent in approaching the wrong forum. Limitation Act?
Basically, my lord, till 2023, it is there, my lord. Communications were there, my lord.
You have to claim such amount within 3 years, I think.
3 years,
Three
yes, my lord,
years.
3 years.
Now,
three
you are
years.
referring to work orders so and so.
Yes.
But work orders will be not the date, isn't it?
Yeah, 20.
Time will start running from the date of claim or what?
No, time will
Time
start
from-
running from date of admission from the
Admission.
head of department, Lordship.
Admission from the head of department.
Yes, and there is no admission from the head of department.
Okay, so time will not run.
Time will not, that time barrier has not yet started.
Time has not started.
Yes.
So there's no impediment in disposing of them.
Yeah, that's why, my lord, in the other, which was disposed of, my lord, that some liberty has been given, my lord.
Court is looking out for you. That's why I'm asking you all this.
Yes, my lord.
Otherwise, simply I would have given you the order.
This is still pending, my lord, for the respondent authority, which was not disposed of yet. That my learned friend has said they disputed the challan and all, my lord.
This is section 12. Oh. No, section 14.
Section 19, my lord.
14.
14.
Exclusion of time of proceeding bona fide in court without jurisdiction. He says that there's disputed questions of fact because they dispute your claim. So, which cannot be settled by a writ court.
Well.
Anyway, you have produced any order like that?
Yes, my lord, that's now I have.
Where? This one.
Para 13, my lord, the observation has been made.
But why do we have to write so much of lengthy order? Is it required?
No, my lord, the only paragraph 13 is relevant.
I'll write a separate order.
My lord.
Heard Mr.
As Hazarika, my lord.
S. Hazarika, learned counsel for the petitioner, and Mr.
R.R. Gogoi,
R. Gogoi, learned counsel,
PH, Standing Counsel, PH.
standing counsel, PhD department. Of having regard to the nature of controversy projected by the parties in the instant case, the writ petition is taken up for disposal. Next para, the petitioner is aggrieved by non-payment of the outstanding bill amounting to rupees 2373,75,2. I repeat, 2373,752 for work allotted by the member secretary What is DSCW? DSSW?
Yes.
DWSC?
District district
wa-
water. No.
Allotted by the district.
PWA. Is
Okay, you find out and let me know. Allotted by the DWSC.
District Water and Sanitation Committee.
Okay, District Water and Sanitation Committee. Come Executive Engineer, PHE Nalbari, Division Nalbari. White work orders dated 1/2/2021, 8/4/2021, 7/4/2021, 5/4/2021, 3/4/2021, 2/9/2021, 24/9/2021, and 6/10/2021 for works related to SBM bracket G as per specifications laid down by the Office of the Member Secretary, DWSC, come engineer, executive engineer, PHE, Nalbari. What steps have you taken?
My lord,
Get this money?
my lord, the work order, we have annexed here in my lord, which was issued by the my lord, respondent authority. These are the annex, and last we have submitted a representation for the payment, my lord, at page 32.
32.
Page 32.
The petitioner for the works allotted had submitted a bill for early payment to the executive engineer, PHE Nalbari Division, Nalbari, on 21/2/2023. But as the same has not been considered and paid to the petitioner, the instant writ petition has been filed. What is your instruction otherwise? You have not filed affidavit in opposition also?
Lordship, affidavit we have filed today, Your Lordship. Affidavit we have filed today, Your Lordship. Just
I
for
see.
record, and the instruction is that, as a verification was done, and thereafter it is said that conclusion that the orders are not supplied to division and the supply bills are not genuine claims and thus nullified. They are not genuine claims, Your Lordship. We're disputing the claims of the petitioner.
Mr. R. Gogoi, Learned Standing Counsel, PhD Department, submits that counter affidavit has been filed today by the department, by which they have taken the stand that the claims made by the petitioner is not genuine, and hence no such payment can be made. Stop considering such stand taken by the respondent authorities. This court, in exercise of its rich jurisdiction under Article 226 of the Constitution of India, would not be able to enter into such disputed questions of fact. So stop accordingly. The writ petition, we dismiss it. What is the word?
This is it. We're able to.
Yes, my lord, it's.
Accordingly, this court, accordingly, the writ petition stands dismissed. Full stop. However, notwithstanding the dismissal of the writ petition, the petitioner would be at liberty to approach the competent civil court for redressal of his grievance, as may be permissible in law, if so advised. Full stop. Registry shall verify the counter affidavit said to have been filed by the PhD department and tag the same to the record.
My lord, one more thing, my lord, the dismissal of this redress shall not be barred to submit the original, my lord, documents and the challenge before the authority to payment the bills. But it is there in the earlier petition, that is. Right.
No, we have not sort of, prevented you from doing all that.
Dismiss on withdrawal, my lord, or approach before the. Because my lord, why I'm submitting, my lord, the work order issued by the respondent authority, my lord, from page 19 to my lord 26, all are issued by the my lord respondent authority. So there is no dispute regarding issuance of work order. Only regarding my lord challan they have disputed, my lord. That's why, my lord, if we pay the original challans and all before the authority without approaching the civil court, so they may go for it or verify it, my lord. Therefore, my lord.
The petitioner is also given liberty to submit the original challans
Challan, my lord, challans.
in support of his claim for the unpaid amount to the respondent authorities concerned, if so advised, to convince the said authorities that the amount indeed is due to be paid to him. Okay,
Hello, the dismissal on withdrawal maybe kindly maybe.
that is not there in the order which you have given me.
Okay, 18 and 19 also similar, my lord. There are different work orders. 17, 18,
18 and 19.
18, 19 also similar. My lord, work orders are different and enterprises are different. Works are similar kind of works.
And our stand is similar.
And the outstanding bills are different.
How much is the outstanding bill?
Second is my lord 54 lakhs, my lord. But 2,61,414. So this total outstanding bill.
Where is that? This is item number 18.
18. 2709.
From where do you say that?
In the petition also said, my lord, in the representation also we have submitted, my lord, at page 17. This is 1,31,864 and 1,29,550. Total, my lord, 2,61,414. Page 17, our representation.
2 lakhs, how much?
2,61,414.
Have you filed an affidavit today as well in this?
Yes, sir, Lordship. In 3 matters altogether, we have filed affidavit. Our stand is similar in all these cases.
My lord, work order is page 12, annexure A, my lord. Issued by the respondent authority. Here, my lord, there are 2 work order issues. At page 14 and page 12.
This is for computer and printer repairing.
Yes, my lord.
Art Mr.
Yes, Hazarika.
S. Hazarika, learned counsel for the petitioner. And Mr. R. Gogoi, learned standing counsel, PhD department. For the respondents. Stop having regard to the nature of the grievance projected by the petitioner. The writ petition is taken up for disposal at this stage. Stop at the outset, Mr. R. Gogoi, learned counsel. Learned standing counsel submits that in terms of the last court's order, the respondent PhD department has filed a counter affidavit today. And stand taken is that they dispute to the claim made by the petitioner. What have you stated in the affidavit?
Same as lordship, we have verified and the material or supply materials, they are not supplied to us, your lordship, and so the bills are not, supply is not genuine. The claims of the petition are not genuine, here, even here, your lordship.
They have, what do they say?
Terms of proceeding person is particular comparable to them, the stand taken is that they dispute but then made by the petitioner.
Claim made by the petitioner is not genuine, and therefore no amount is due to them, due to the petitioner. So stop. Next para. Grievance expressed by the petitioner in the instant writ petition is that he has not been paid the outstanding bill amounting to rupees 261,414 for work allotted by the member secretary, DWSC cum engineer, executive engineer, PHE, Nalbari division, Nalbari. White two work orders dated 29/11/2021 and 30/11/2021 for computer and printer repairing, and also for supply of contingency materials as per design and specification of SBM-G. Now, despite the bill submitted by the petitioner before the executive engineer, PHE Nalbari division, Nalbari, the said authority has failed to pay the outstanding dues, and hence the instant writ petition. You have a copy of the affidavit?
I have a soft copy, your lordship, if I can give it a mail, a soft copy I have.
How many pages are there?
I don't know, 3 to 4 pages,
4 pages.
5 minutes.
Miss, please furnish that. Next para, Mr. Arak Gogoi. Learned Standing Counsel, on the other hand, submits that. On the other hand, by producing of the copy of the counter affidavit filed by the department today, it submits that the claim made by the petitioner for having rendered services and for supply of the materials is highly disputed by them, and that according to the department, no such amount is payable to the petitioner. So considering the dispute, this court, in exercise of its jurisdiction under Article 226 of the Constitution of India, cannot adjudicate such disputes, such matters which involve disputed questions of fact. So accordingly, the writ petition is dismissed. Stop, notwithstanding the dismissal of the writ petition, the petitioner will be at liberty to approach the competent civil court for mitigation of his grievances as may be permissible in law. So additionally, the petitioner will be also at liberty to produce any such documents which support his claim for payment of the due amount before the respondent authorities,
paragraph 5 of the affidavit, one better
To-
capital C.
not to in support of his claim for the dues, if so advised. Can you just go back to some lines? Affidavit of possession, I said, no? Producing an affidavit of possession, submits that. Just read. What did I tell you? On the other hand, Mr. R. Gogoi,
Claim made by the petitioner is genuine and therefore no amount is put to the petition.
okay, so stop there. After that, you just add. He submits that the petitioner has failed to furnish copies of the delivery challan duly signed by the receiving authority in support of his claim for the due amount. Then how will it continue? You will add that in that paragraph. Then how will it continue? After that, what will be there?
I agree expressed by the petition by the institution is that they has not been paid the outstanding bill amounting to rupees and for work allocated by the member secretary, which can executive engineer pays number division number by 2 of orders to 29/11/2021 and 30/11/2021.
Okay, okay. You will do. So this takes care of this case, then the other case?
My lord, other case item 192710 WPC. My lord, here,
One more line you just add. The counter affidavit said to have been filed by the PhD department today will be tagged along with the stem. Will be tagged along with the record. Yes.
here, my lord, 5,45,810, my lord. Page
This is a breakup, isn't it?
Yes, my lord. The page 24 is a breakup and total amount is 5,45,810.
This is for what?
This is for supply of, my lord, A4 size papers, computer materials and motherboards and etc. Materials regarding to, my lord, stationary items.
Mr.
Yes, sir.
Sorry? S. Hazarika, isn't
Yes,
it? S. Hazarika, learned counsel for the petitioner, and Mr. R. Gogoi, learned standing counsel, PhD department, for the respondents. Stop having regard to the nature of grievance projected by the petitioner. The petition is taken up for disposal at this stage. Next, whether the petition is agreed by the non-payment of the outstanding bill amounting to rupees 545,810 for work allotted by the member secretary, DWSC, come engineer, come executive engineer, PHE, Nalbari Division, Nalbari. By work orders dated 2011-2021, comma,
Page 13 to 22 are the work orders.
Then we write two work orders, both dated 2011-2021. And also three other work orders dated 23/11/2021, 25/11/2021, and 9/11/2021 for repairing of computers and printer under SBM bracket G, as well as for supply of contingency materials. So although the petitioner submitted his bills to the Executive Engineer, PHE Nalbari Division, Nalbari, on 21/2/2023 for payment of the aforesaid amount. But however, as the same was not paid, the petition is before this court. Affidavit?
Yes.
Next para, Mr. R. Gogoi, Learned Standing Counsel, PhD Department. On the other hand, submits that affidavit in opposition.
And it's not the recorded lordship.
Has been filed by the respondent department in terms of the last court's order dated 17/12/2025 today. And that, as per the stand taken in the said affidavit,
Para 5.
the petitioner having failed to furnish copy of the necessary delivery challan duly signed by the receiving authority to show that the items were duly supplied and received by the respondent, there is no question of payment of the claim amount. The Learned Standing Counsel submits that, in other words, the respondents have denied of having any dues to be paid to the petitioner. Stop. To support his submission, Mr. R. Gogoi, Learned Standing Counsel, has also produced a copy of the counter affidavit filed today for perusal of the court. Next para, upon considering the submissions made by the learned counsels for the parties and upon perusal of the materials available on the court, this court, in exercise of its with jurisdiction under Article 226 of the Constitution of India, cannot adjudicate the claim of the petitioner, since disputed questions of fact are involved. So, as such, the writ petition is dismissed with liberty to the petitioner to approach the competent civil forum to mitigate his grievance as may be permissible in law. So it is also, the liberty is also given to the petitioner to submit the original challans or receipts to the respondent authorities to support his claim for the due amount is so advised.
My lord, I'll be highly obliged. Kindly this dismissal on withdrawal word may be added, my lord, instead of dismiss, my lord. It will be helpful for the petitioners who approve before the liberty, my lord.
Okay. Then what is that line I said? Dismiss part? Huh? Before that, what did they say? Okay, I'll see to that. You type it out, I'll see later.
I'm highly obliged.
Obliged, Lordship.
How many matters are? 5 matters. So, remaining matters will give a date. Kindly inform the court master, if there's any interim and all that, let us know. Matters.